मतलब item number 58, my lord, today's list. My lord, this matter, my lord, but is covered by a, my lord, decision of a division bench judgment, my lord. Where, my lord, the termination of a contractual employee, my lord, is held to be, my lord, illegal without notice, my lord, when you are, my lord, arrested. Well, may I pray for, my lord, upgradation?
Upgradation. Why? We complete this. You wait for your time. What is that hearing hurry for upgrading?
Chance of,
Huh?
chance of reaching the matter.
Really? Okay, we'll see. Yes. If it doesn't reach, we'll call up the matter.
For listing of
Motion, no?
May I please do? So, I am before the lordship, challenging a transfer order. My lord, 24 hours time was granted. So, my lord, I filed it morning and it was, my lord, already numbered, my lord. Production list.
No. Monday.
Otherwise, my lord,
You go and join. We'll bring you back on Monday. Don't worry.
may I please do?
Yes.
The concern of the other side, I beg to mention item number 56.
86.
56.
56.
We have to file this matter, we have to file affidavit in opposition.
56. You are for the petitioner.
Respondent. I am for
Respondent.
the
Any objection?
petitioner. No.
56 on the request made on behalf of the respondent counsel. Matter stands deferred. We listed after 3 weeks. Mr. Rarsina
May I pay for a fixed date?
appears for the petitioner. Matter be listed after 3 weeks. You want to file affidavit?
Yes.
Once you file, you make a mention. We'll fix your date.
I take it.
Yes.
With the concern of other side, I beg to mention item number 44 to 47.
Huh?
44 to 47. 45, 45, 40, and 47. Therefore, the respondent IOCL lordship may grant us 3 weeks time for filing our affidavit. We have taken
44 to 47.
47.
Who's for the petitioner?
We have taken consent. Ask for
44 to 47. Counsel for the IUC, Mr. K. Kolita, pray for adjournment. Submitted that consent for counsel for the petitioner. Payment is allowed. List after 4 weeks.
Hello.
My lord, I beg to mention for
Next week is difficult. You have to wait till next week is the motion day. All day motion. All week motion. Vacation. Vacation. $20.
Item number 25, my lord. Please place it. But I'm adjourned for 1.
25.
Yes.
So the petitioner.
My lord, I am for the petitioner, my lord. My lord, the pensionary matter, my lord. So, my lord, I am praying for a date, my lord. Date application.
Why are you agreeing to an adjournment?
I am accommodating
For what purpose?
Not yet filed, my lord.
Huh?
Exhibit is filed.
that's my lord.
Then let the affidavit be filed. After that, if required, you make a mention. Because you may like
No,
to
I am not mentioned, my lord. Yes, sir.
after the affidavit is filed, you may like to file a rejoinder. What is the point in fixing a date? Let the affidavit be filed. If not filed, you make a mention.
My lord, pensionary benefit, my lord, nothing was granted, my lord. That's 22 years. That's because, my
When
lord,
you wait for the matter to be called up, let it be called up. Yes.
May I please, your lordship, I beg to mention for listing.
Writ petition for admission on 24th of July. July.
She got item 49 and praying for adjournment.
49. 49. Yes. Who's for the petitioner? Any objection? 49. The request made on behalf of the PNRD department. Matter stands referred to be listed after 4 weeks. Mr.
yes, sir.
S. Ahmed appears for the petitioner. Does not object to the prayer made. Relist this matter again after 4 weeks. Interim order, if any, will continue. Yes.
Section 11 petition. The arbitration clause is at page 82.
80.
82 lordship. This is at page 185,
82.
82. Clause 64, demand for arbitration. Railways law.
Heard letter counsel for the petitioner, Mr. M. Sahiwala, also heard Mr. A. Gupta, counsel for the railways. Is an application under section 11(6) of the Arbitration and Conciliation Act seeking an appointment of an arbitrator. We should notice return over 4 weeks. If the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Respondents may file their objections if any. Yes.
Non-compliance of the order dated 18/6/2025, fasting WPC 1160/2025. What happened in this case, Your Lordship? After receipt of the representation, detailed representation and hearing was conducted, thereafter speaking order is supposed to be passed, which is not yet passed in this case, in compliance with the order passed by this honorable. By the respond number 2. Extra 4, wherein hearing was conducted on receipt of the
Third counsel to parties issue notice written about 4 weeks. Steps of the respondent by speed post within 1 week.
Pertains to my dismissal of service.
Dismissal of service.
Yes,
Filed appeal?
not fine.
Why you not filed appeal?
Because my lord, the petitioner furnished the documentation to me. I was in jail, my lord. I
Heard
was subsequently
counsel
released.
for the petitioner should notice written about 4 weeks. The petition is filed putting a challenge to the order of dismissal.
Yes, my lord.
Where is the order?
What are my lord? My lord,
74.
yes, 74, my
Order dated 1410.
1410.
State is represented by MLB government,
No.
appearing for all the respondents. Therefore, notices are waived, extra copy will be furnished within a week of 1 week. Released after the returnable date.
Right. Kindly see the last order.
Instructions. Yes.
Third paragraph.
There is some interference. Huh? In the advertisement.
Lordship, that section 5(1), my lord, that there, this was, my lord, an advertisement. It was challenged before this honorable. That council candidate was, my lord, debarred from the, my lord, to participate in the, my lord, interview.
So the proceeding is state, advertisement process, the recruitment
Lordship, my lord,
process is
that,
state.
regarding only that portion, it was, my lord, state lordship. My lord, the court was directed.
No,
towards
your communication said
Lordship,
further process of recruitment is
Lord.
10 state.
Lordship. Process has been state, Lordship.
Oh.
Now, my lord, that government has taken step, my lord, that they have to place before the cabinet approval for my lord,
In
the further.
deference to the earlier order dated so and so. That's Council for the Revenue has placed before the communication 26. So as per the said communication, it is stated that in view of the recent judgment of this court, whereby sub-rule 1 capital A of Rule 5 will be struck down. The further process of recruitment pursuant to the advertisement
Dated 14/4/2026.
dated 14/3/26 has been stayed. Matter is presently being taken up by the directorate with the government in the revenue department for further amendment of the rule. That view of the matter stands deferred to be listed after 4 weeks, and the standing council apprise the court on the next day. List after 4 weeks.
Five. Notice you put
Where
this matter, Lordship.
this matter,
So, Lordship, for it. Item
no,
4.
this is health matter. Which matter?
No, no,
The
4.
earlier matter.
Item 5.
Earlier matter, you tell us what step. If you're cancelling, then what is the point in going ahead?
Like,
Met with the lordship. My lord, this instruction was sought for the lordship, page 18 to 24.
Here, Mr. Bora, what
My
instruction?
lord, the instruction that I have received says that, my lord, the petitioner is not science. Because for the post of laboratory technician, the qualification required is HS in science plus the required course. But he is from art stream, my lord. That's why, my lord, regarding his appointment, my lord, the concerned principal has sought for a clarification from the director of medical education.
Where is the advertisement here?
In the advertisement, it has not been stipulated, my lord. But otherwise, the relevant rule says that, my lord, he must be a
Page 18, where?
Page 18 is the advertisement. 6/12/2024.
Where is the post?
Post is your lordship, my serial page 19, my kindly looked into your lordship.
ICU,
Item number 24, you do laboratory technician.
laboratory technician.
Technician, your lordship, and my qualification, your lordship, diploma in medical laboratory technology, annexure 1, page 17, your lordship. So there is
The advertisement does not.
yes, my lord.
It is arts or science.
advertisement doesn't stipulate the same, my lord, but otherwise, my lord, the relevant rules, my lord, as per the stipulation in the relevant rules, my lord. That's why, my lord, the concerned principal has sought for a clarification.
Where is the appointment order?
appointment order is at page 25, your lordship. Page 25.
25.
20 December 2015, my appointment was by the Director of Medical Education. So far the instruction derived, your lordship, I don't have the, your lordship, supporting documents, but the similar, the candidates who are on the similar footing, your lordship, already been appointed, your lordship. Now the respondent authority cannot travel due to, your lordship, because there is no specification, your lordship, in the advertisement itself. Once the game is over, your lordship, I have duly participated in the recruitment process, your lordship. So after accomplishment of the recruitment process, your lordship, written as well as viva voce, your lordship, have been selected, and your lordship, as per the director of the, your lordship, that is respondent number, I approach twice. Response number 2, Your Lordship, the Director of Medical Education, as per his instruction, Your Lordship, I have approached time and again before the principal, because the principal doesn't have any, Your Lordship, domain, Your Lordship. It is totally under the,
My lord, this relevant inspection, your lordship may view.
Where is the rule? Rule?
Rule is also there, my lord. My lord, the preliminary inspection I have received, give me some time, my lord. I will file a detailed affidavit, my lord.
The rule is not enforced here.
If there, my lord.
So the rule has been referred, but the Assam Laboratory Technician Service Rules.
But just now I have received this preliminary inspection, my lord. That's why, my lord, give us some time, my lord, we'll file an affidavit in detail. Because on earlier occasion also one similar
Right.
request.
Third, Mr. A. Devan, petition, and Mr. Bora, Learned Counsel of the State Health Department. As to the earlier order, Mr. Bora has obtained the required instructions in the matter. See, the petitioner not required qualification as stated under the Assam statement. Under the said rule, said qualification is at the level of higher secondary science. Each SSLC science. So, petitioner is submitted to the petitioner. Studied does not qualify as HSSLC science. So submits that you would like to obtain the required instructions, further instructions in the matter, and apprise the court, and also file an affidavit. Accordingly, that notice issue will come. So, file the complete their instructions and file necessary affidavit. Meanwhile, the post to which the petitioner was selected and appointed should not be re-advertised or filled up without leave of the court.
matlab like, it date the timing.
10th of August.
No problem.
Apply.
Instructions.
And then on compassionate ground, after that, Lordship, as a worksite employee, after that person to a High Court's order, he was appointed on regular basis from the initial date of appointment. All the consequent benefits were given except the notional seniority. Now, Lordship, if the notional seniority is not given, all my juniors would be promoted, and I'll now not have any avenues for promotion. Therefore, I had annexed a order which is on similar facts, same department, and the stand of the respondent is also similar. So on the last occasion, Lordship, instructions were, I had submitted instruction, maybe not whether it is similar or not. At page 45.
I have received the instruction, my lord. I may be allowed to file my affidavit.
Here also in this order, he was appointed on compassionate ground. He works as a worksite employee. Then he came for regularization and other benefits.
The council was asked to examine whether the judgment at page number 45,
As per my instruction, it is not covered by
it
that,
is not covered.
so I may be allowed to find my.
Not covered as per.
Yes, but just I had also seen the judgment, the facts, the stand of the department and the final, only the thing is that they have come for regularization also. In my case, I was regularized from the date of my initial appointment and all the consequential benefit was already given. Therefore, it,
Let them file their
Yes.
affidavit if they want. But
yes, yes,
counsel for party should consider. M.S.M. Das, standing counsel, Peter, appeals for respondent. All the respondents. 1 to 5. Who's for finance? Mr. Ray Botabu for finance. Since the respondents are represented, notices of waived extra copy furnished within a period of 1 week from the.
only thing in the meantime, if some promotional process takes place, I mean,
First, your confirmation has to be accepted.
but otherwise, page 27, I have been regularized from the date of my initial appointment.
What is your prayer now?
Prayer is for only for the notional seniority.
Then what are you worried about further promotion?
Lordship, I have been promoted, I have been appointed as regularized as junior assistant. The next promotion is senior assistant.
So if your eligibility will be considered,
Otherwise, all my juniors who were appointed in 2020 would be senior to me. If my notional seniority, otherwise, if they file the affidavit quickly, Lordship.
yes, file your affidavit at an early date. Which date? Of course, after vacation, give us a time to 3 weeks.
First of all,
Listed after 3 weeks. 31st of July.
problem. Make me the check.
Principal notification asks to receive instruction whether any further redressal avenue is there or not. The petitioner can file a revision under Rule 54 law. So the next superior authority,
Are you challenging the dismissal order?
dismissal.
Lordship, I'm challenging the dismissal order and the appellate order whereby the dismissal was confirmed.
Well, you should notice here. You should notice.
Yes,
Heard,
my
counsel
job.
for party. Honorable Holmes. Mr. D. Chakravarti, CBC appeals for all the respondents. For notices of waive, extra copy will be furnished. Respondent may complete their instruction and file a survey.
Discuss my work. Respondent 6 has been engaged as a Ram's Rozgar and against that the representations were made on the ground that he is the administrative head and his wife is the elected member of the same panchayat.
Who are you?
I am the Ram Sabha agent in passed a resolution and authorized me to file.
Huh?
Ram Sabha has passed a resolution. My lord will find it. Case 51.
51.
Yes, my lord.
No, but who are you otherwise? The member or president?
I am the resident. I am the resident.
Resident.
Yes, my lord. And I have been authorized by
You
this
are a
resolution.
member of the Gram Sabha.
Yes, my lord. This is the resolution of the Gram Sabha.
Have you filed any, ventilated your
Yes, my
grievances
lord.
against the
For
authorities?
all the respondent number 5, the block development officer has engaged, and against that we have approached before the chief executive officer, the Jilla Parishad, then the deputy district commissioner, and at last we have approached before the commissioner Panchayat and Rural Development. No decision has been taken. So my only humble prayer will be that the authorities may be directed to consider our representation and disclosure by a region order.
Yes.
They can consider the representation.
Heard. Parties. Petitioner is the member of You are a
I'm
member
a
of the
resident, my lord. I'm the resident of Gram Sabha.
resident
Yes.
of which village?
Vileja Gaon Panchayat.
Huh?
Vileja Gaon Panchayat.
Vileza Gaon Panchayat.
Yes,
area. Under block, under Ilajhari Group C Development Block, Koma Itar Veta Hauli District, Borpeta. The petitioner is before the court has their grievances ventilated by representation. Where is your representation?
My lord will find it is 34 onwards, 34, dated 11/5. For the block development officer of the same date before the deputy commissioner.
Representations before the block development officer, Ilajhari C Development Block,
Page 37.
Chief Executive Officer, Borpeta Zilla Kozhikode, Borpeta,
Then my lord, page 40, deputy
Deputy Commissioner, Borpeta District,
Then my lord will find page
and
43. For the
the
commissioner.
Director and Commissioner, Panchayat and Rural Development, Assam, has not been redressed. So the basic grievance of the petitioner is that the private respondent number 6 was appointed as a Gram Rozgar Sahayak. In addition to his regular duty as Gram Rozgar Sahayak in Haldia, Tengagaon Panchayat. As much as that the spouse of the respondent number 6 is an elected member and serving as working/ward member of ward number 1 of the Udeza Gaon Panchayat. So he submitted that the private respondent number 6, being the husband, is acting as an executive public works employee under the government, while the spouse of respondent number 6 supervising elected authority serving as ward/working member, and there being and this has happened because of nepotism and Gaon Panchayat members apprehend serious financial malpractices. So, but the representations preferred have not been addressed. Council for the petitioner submits that by a resolution adopted by the Udeza Gaon Panchayat, the petitioner has been authorized to file the representation, to file the petition on behalf of the members, stop the special emergency public Gaon Sabha 37 or number Udeza Gaon Panchayat held its meeting on 14/5/26. And by the 5th resolution, the petitioner has been selected or appointed as a representative on behalf of the common people and has given him the responsibility for filing the case or taking any other legal action. Stop. Therefore, the present petition is filed. Stop. The only limited prayer before the court is seeking a direction to the respondent authorities to consider the representations filed and dispose of the same by passing a speaking order. So, there are Mr. E.P. Ghosh, standing counsel PNRD, does not object to the prayer made, considering the same, the petition stands disposed of, directing the respondent number 2, 3, 4, and 5 to dispose of the respective representations addressed by the members of the Gaon Panchayat, Udeza so-and-so Gaon Panchayat, as stated in the writ petition. So the said respondents will consider the claims of members of the Gaon Panchayat and thereafter. But it is better to have one representation disposed of unless
26-5 may be considered by the last by the commissioner.
court considers it appropriate to direct the commissioner
Yes, my lord. Page 40,
to dispose of the representation. Page number
43, my lord.
pending before it, stated to be pending before it and filed by the respondent authorities. The respondent commissioner will examine the claims and thereafter pass a speaking order on the claims made by the respondents. Same be done within a period of 30 days from the date of receipt of a certified copy of this order, writ petition accordingly disposed in terms of the order.
Principal personal hearing maybe. No.
The pension matter. The petitioner is entitled to get 50% of the pension.
You are first wife or second wife?
I'm daughter of second wife,
You are daughter of second wife,
unmarried daughter.
unmarried daughter.
But yes, for Annex 8, impugn data, page number 27.
You examine and release the claim.
My lord, lordship has taken up the matter of the first wife on the 16th of this month, my lord. So they have taken instruction to whether they'll withdraw or not. My lord, the issue here is the non-submission of NOK. They have submitted the NOK. The
No,
petitioner-
which item?
My lord, on 16th, my lord, this order has been passed.
In the same matter.
No, my lord, this is the first wife. And they are the daughter of the second wife. So lordship may take up both the matters. And because of the non-submission of this NOK, my lord,
Why? You have
And my
not
lord,
submitted NOK.
they have
No,
submitted.
I have submitted,
Ah,
but the first wife has not submitted NOK. That's why the disbursement has been stopped.
Where is your NOK?
Yes. Annexure. Annexure 2, page 20. And again, 21. Page 20.
Who is Nirupama Hoikia?
I'm a second wife.
Second wife.
Petitioner is the daughter, unmarried daughter.
Huh?
Petitioner is the unmarried daughter of the
What is her name?
Nirupama. Petitioner name is Susmita Rama.
Oh,
She is the daughter of the second wife.
oh.
She is unmarried. She is entitled to get a pension.
You are not entitled. Under the rules, it is the first wife who is entitled. But
No.
you are entitled to
I
be.
am the daughter of the second wife.
What does the rule say?
My lord, as per the rules, they are entitled, my lord, the second daughter of the second wife. But my lord, because of the non-submission of the corrected NOK in their case,
No,
because the name of
that
the
is
first
what
wife
we
is
want
not
to ask you. You are releasing pension to whom?
my lord, to the first wife as well as the daughter of the
Two
second.
separate FPPO or one?
My lord, because the daughter of the second.
Are you releasing the family pension payment order individually or just one?
My lord, that I have to take.
You are releasing only one family pension payment order to the wife, and she is supposed to share it with her stepdaughter.
My lord, otherwise there is.
So what is happening? Second wife applied for family pension. Then in the meantime, first wife come and hurt the both the parties.
Right, it is submitted that it is a connected writ petition being WPC 2955 of 2026, which is also a claim made by the first wife for pension. First wife of late Ramakanto Rabha for pensionary benefits stopped the present writ petitioner, unmarried daughter. of let Ramakando Rava out of the second marriage. Let his petition be listed along with WPC 955. After 3 weeks, on a date to be fixed by the registry, and the respondent meanwhile obtain their instructions in the matter. Although notices are not issued, extra copies will be furnished. Mr. Das for APDC. MS Open for AEDC.
Respondent four.
Respondent.
Apply.
Apply. Yes.
Plain terrace from my pension as this respondent
claiming
authorities releasing my pension very lately. I approached the High Court earlier, so 77 for the petition 7794 of the 2017. That order High Court has given verdict in para 11, when my lordship page number 42. Para number 11, in their judgment, it is vividly said that accordingly, after hearing the parties, this writ petition is disposed of with the following directions. A. State respondents will pass appropriate orders for grant of seniority to the petitioner in terms of the admission made by the authorities in their affidavit in opposition, and thereafter grant the consequential benefits of promotion to the higher post of leader and additional director, and as such benefits be given from retrospective effect if necessary. Then my lordship kindly see the page number 44, annexure 4, and relevant portion is type copy, minutes of the meeting of the Departmental Promotion Committee, DPC, held on 21/10/2020 at 1 p.m. in the office chamber of the Commissioner and Secretary to the Government of Assam, Elementary Education, Department in
Mr. Talukdar.
This lordship paying for interest on delay settlement of pension. So at this stage, lordship, let it make lordship on what basis delay has been caused.
Respondent is the Education Department.
Respondent number 1.
Education. Why is it before this bench? Should be before bench 2. Civil bench 2, education matters. Service matters of education department. Should go before civil bench 2, not the appropriate bench. It is submitted at the bar that the matter pertains to civil bench 2, Roman 2. Registry will verify and place the matter before the appropriate bench next week. Please take steps accordingly.
So the grievance of the petitioner is that also he has rendered also more than 6 years of service, and thereafter he resigned from the post in 2023. Now, as per the gratuity act, the employees who has rendered continuous service for more than 5 years, they are entitled for gratuity. So here, the authority has done, although I approve the gratuity amount is not released, as well as the NPS accumulated corpus fund, that amount to 3 lakh something, that is not paid.
Counsel for party issue notice. Mr. P. Bora, State Council appears for all the respondents. Extra copies will be furnished within a period of 1 week. Returnable for
One of the pendency shall not be barred.
pendency of the
Release the
petition
NPS
shall
amount.
not be a bar for release of gratuity and
NPS accumulated corpus.
NPS and accumulated corpus.
NPS
accumulated corpus.
That amount of is 3 lakhs.
Whatever it is.
Not. Apply.
Is there a scheme under the bank?
Yes, sir.
Get your instructions. Heard Mr. Sharma. R.K. Sharma, counsel for the petitioner, Mr. A.K. Ganguly. A. Ganguly appears for
1 to 6, 7 is the union.
1 to 6. And M.S.B. Sharma for respondent number 7. Since the council are represented, Union of India. Since the councils for the respondent are represented, notices of the extra copy furnished within a period of 1 week. Might have been listed after the returnable date.
After 4 weeks.
4 weeks.
This one is covered by your lordship.
What that?
Page 151 your lordship. They are community health professionals your lordship. Similarly, secretive candidates have come. Your lordship has made certain directions. This in fact covers them also, but they are apprehensive that
Huh?
They are paying for the civil alia.
your lordship has directed to constitute a committee your lordship.
What direction?
Your lordship will kindly come to page 87 or page 231, para 87. Specific directions.
The heard counsel for the parties, the writ petitioners claim to be rural health medical practitioners under the erstwhile. What is the
Assam Rural Health Regulatory Authority Act 2004.
Assam Rural Health Regulatory Authority Act 2004. This act came to be struck down by the Gauhati High Court and the matter traveled to the Supreme Court. Supreme Court upheld the judgment of the High Court. So pursuant to the striking down of the 2004 Act by the Division Bench of this court, the subsequent act being Assam Community Health Professional in bracket Registration and Competency Act 2015 was incorporated. Stop. This the validity its act was also challenged before the apex court. Constitutional validity of the act was also essayed before the Supreme Court. And Supreme Court by judgment and order dated 24/1/2023 passed in civil appeal number 7, while upholding the judgment and order passed by the division bench by the judgment and order striking down the act of 2004, declined to interfere. Declined to hold. As also concluded that the 2015 Act was constitutionally valid. Supreme Court laid down several directions. However, these directions have not been complied with. A group of rural health practitioners, now renomenclatured as, subsequently now you're called as?
Rural health practitioners. So
No.
community health.
Community health. Community health
Professionals.
professionals. As under the Act of 2015, that approached this court by filing WPC number so and so, which came to be disposed of by judgment and order dated so and so. Whereas the present writ petitioners claim to be similarly situated like the petitioners who have filed this WPC number so and so and have prayed for similar directions to be issued. Mr. D.P. Bora does not object to the prayer made. Accordingly, the petition also stands closed in terms of the judgment and order dated so and so passed in the part of WPC so and so. The respondents carry out the directions contained in the said judgment Relevant paragraphs are extracted from the para 89 to 90. That petition accordingly stands disposed.
Public.
Matter relates to transfer of the member of the railway protection force. Yesterday, when that similar matter, I have no detail of.
What order we passed?
And not to give effect the
When is the matter fixed?
24 month.
24th. Fix all these on 24th, get your instructions.
Only the thing is that in this case, my lord, they have been spared.
They have been
Released.
released. They
So,
released.
and here, my lord, the order has been passed not to give effect, subject to the condition that the petitioner not been released as on date. Now, in this case, my lord,
They are released. So we connect these matters only on 24th.
24. Till then, status quo maybe.
What's, if they release, they
They are
release.
released because we are not going to join. Otherwise, they'll take some action. My lord.
No, no, if your status quo would mean as is
As
the
it-
position today.
I am released, I will
So if
remain
you're
released.
released, you're bound to join. If you don't join by projecting the status quo order, is not going to come to your aid. Status quo will come to your aid only when the release order is stayed.
Or when the transfer order
We'll
will
pass similar order.
be a similar order.
Heard, council to pass mutual notice. That will be listed for instructions on 24th,
24, correct.
along with WPC
WPC 3188.
3188 of 26. As it is stated, that similar matters are fixed on 24. So far as the prayer for interim is concerned, status petitioners are not released in the meantime. It's on 24. Respondent will obtain required instructions in the matter. And although notices are not issued, extra copies will be furnished within a period of within the course of the day.
Daily.
Mr. D. Kaushik appears for the respondent. I Rafiq for the petition.
This time you okay?
Similar matter.
Similar. Here, my lord, they have just sent the spared order while we are on leave.
Same order.
Same order.
24. Then get your instructions. Heard learned counsel for the parties issue. What about the objection? Any objection in the implement? Huh? No. Heard learned counsel for the petitioner. Is there application I has been filed seeking implement of the party number 5 with the party respondent in the accompanying writ petition, namely WPC so and so. So the case projected by the petitioner in WPC so and so is that respondent number 5, opposite party number 5 is his spouse.
Ex-spouse.
He have gone through a divorce.
Yes, madam. Divorce already
Was
done.
his former spouse, whose name was entered into the service records of the writ petitioner as a nominee. So subsequently, on charges of murdering mother of the petitioner, the former spouse was proceeded with and is incarcerated now.
No, my lord, trial is going on.
Right, and the trial is proceeding. Meanwhile, the petitioner and the opposite party number 5 had petitioner had divorced his spouse, being respondent number 5, by executing a talaknama
Yes, my lord, under the relevant Muslim law, my lord.
under the relevant Muslim law. So, nevertheless, this court was of the view that the private respondent number 5 was required to be arrayed as a party, as the prayer in the writ petition was to strike off the name of party number 5 from the, as a nominee service record and instead enter the name of the petitioner's father. Present petitioner applicant will therefore file an IA implement of respondent number 5. So, Colonel CGC and his IRDE will not object to the prayer made accordingly. Stage without issuing notice, the I stands allowed. Hearing respondent number 5, opposite number party number 5 is respondent number 5 in WPC number so and so. The opposite party number 5 will not be prejudiced as she will have ample opportunities to file objections and affidavit in the accompanying WPC number so and so during proceedings pursuant to her implement as respondent number 5. So I accordingly stands allowed. Petition respondent number 5 so and so number arrayed as opposite party number 5 is arrayed as respondent 5 in WPC number so and so. Petitioner will file amended course title within 1 week from today, and thereafter petition will be listed. I accordingly allowed dispose of the petition to write view of the order passed to this one so opposite party opposite party 5 in I number so and so is arrayed as party respondent. Petitioner will file amended course title and thereafter the petition will be listed.
Public.
This will be heard along with item number 48, you know.
Petition be called up along with item number 40. Along with item 48.
48.
Said it is to be heard with 48. You wait, you call up 48 and the motion together. That is your prayer, isn't it?
Correct. I need the for your lordship.
This is a fresh motion.
Fine.
So we'll have to permit the respondents to obtain instructions, issue notice. Now, if you want this matter to be heard along with a matter which is listed for admission, then we'll have to call up this motion matter along with the admission. What do you want? It to be called up along with item 48 as per the petition. Yes.
Appointed on 13/7/2020. Thereafter, my lord, he is working as a Sambandbadi helper. Subsequently, advertisement was through. My lord, annexure 4, page 70. And that advertisement, my lord, these helper are to be promoted, upgraded Sambandbadi worker. In the advertisement, my lord, the column number 5, some condition is there. The HSLC examination passed and my lord 10 years or more experience. I am the my lord the 10 years, more than 10 years and my lord HSLC passed. And response number 5 is the 9 pass candidate. So I came to know my lord he is a selected and 9 pass candidate. And it's one of this my lord this advertisement.
We'll have to issue notice here.
Right.
Heard that the council for party issue notice for week. Mr. CK Guru IPS for respondent 1 to 3.
1 to 4.
Paper notice of the waive, extra copies be furnished within a period of 1 week. Steps on respondent 5 by speed post within 1 week. That will be listed after the return to pay.
My lord, this in prayer, my lord, is the suspending the process of the appointment of the response number 5.
I will issue notice on interim prayer, fixing the matter on 31st of July.
The maintain, my lord, 9 pass already appointed, my lord.
If it is appointed, then appointed because you have married her as a party. Without notice, how do we stay there? Or if you want, we say that any appointment made to respondent 5 will be subject to outcome.
Fine.
Huh? All right, then you say that so the appointments that may be made The respondent number 5 shall be subject to the outcome of the present litigation.
My lord, in this, I was supposed to get an instruction, my lord. I will get further time, my lord. Yes. Otherwise, my lord, if we, my lord, take up the matter on merit, my lord, there is nothing in this case.
No, my lord, they will have to produce the record, original record. Today you will judge. There is an order, honorable court's order. Let them produce the original record. Here they have taken time, you will judge.
So you are directed to produce the original record.
My lord.
You have the record?
No, my lord, it doesn't come, my lord.
Huh?
It doesn't come, my lord.
It will come.
No, my lord, I need some time.
In reference to the earlier order dated 14/5/2026, the Home Department was directed to produce the records containing the original communication, undated communication, which is relied on by the department to say that the petitioner was not offered the appointment because he had declined to join, and which document is disputed by the present petitioner. Mr. Hall submits that he would require 3 weeks further time to produce the said report. Mr. R.M. Chaudhary, on the other hand, submits that the matter be listed on a fixed date.
Right.
List on 31st of July. Pass over. It has been issued here. Matter is to be listed for part 2 hearing. Why is it listed today? No, there is an order on 1/4. The matter should be listed in the part 2 hearing list of June. By order dated 1/4/2026, the rule was issued and the matter was directed to be listed in the part 2 hearing list of the month of 2026. So, since this registry had not listed the matter for a part 2 hearing list, the registry will list the matter in the next available part 2 list for hearing. Yes.
Yes. In this case, you have filed an affidavit on 27/5/26, but it is not on record.
Not on record.
Yes.
It is submitted by the counsel for the petitioner that rejoinder affidavit.
Yes.
Was filed with the petitioner on
5/2020.
25/7/2026. The same is not on record. Therefore, the registry to trace out the said affidavit stated to be filed by the petitioner and connect the same to the case reports by the next returnable date. Release this matter again after 3 weeks. 3 weeks.
Yes.
Yes.
Item 17.
17 was directed to be listed in part 2 hearing list. It has not come. So we have issued another direction to have it listed in part 2.
Hearing list.
Part 2 hearing. Rule was already issued.
On which date maybe?
No date, part 2 hearing list.
This case relating to minor pensionary benefit out of the children out of the second marriage and second round litigation. So this case is equally covered by your lordship judgment and the proven judgment of our High Court.
only the minor is depriving from getting pensionary benefit over deceased father's lordship. We have to on honorable High Court. Clearly, your lordship has directed the authority to proportionate sharing of the pensionary benefit, but due to non-application of their mind lordship and inability to perform their duty lordship, they
Who are you?
lordship,
You are the
children
second wife.
lordship out of the second marriage. Minor one is
Children
the,
out of the second marriage.
yes, minor daughter. One is minor daughter, and another is the major lord.
Lordship, let me file the affidavit. I'm looking at the Paras comment.
No, it
What
is
para were you?
Otherwise, as per the Paras comments, your lordship, they themselves have not filed any application as a seeking pension. So let me file this on, bring it on record, your lordship, this particular fact, because they have to file an application seeking. Otherwise, the authority says that we have no record.
We will direct them to go and approach the authority,
Yes,
file
that can
this
be, that is also,
no law.
if they have to,
application.
they have to file a
You
fresh
examine
representative.
in terms of the judgment and
Yes.
the rules and
Yes.
decide the matter.
Lordship will dispose it of.
Your lordship, earlier occasion, your lordship has specially directed to the authority to make proportionate share of pension lordship.
That is what we direct them to do. Now,
It's lordship, but did make any fix and fix for final hearing. Then
not
also
final
your lordship
hearing,
judgment. Your lordship judgment has
we are
equally
listen to
covered
the
in
court.
this case.
Please listen to the court. We are closing the matter, directing, remanding the matter to the authorities. They will examine the matter in terms
No,
of the
lordship,
rules.
if directed the authority to examine the same, they have again do so, lordship.
Do what?
Earlier occasion, lordship, your lordship has directed the authority to make proportionate share
Where?
of the
Where?
pension.
Which
Yes,
order?
your lordship judgment. Your lordship order.
Where?
Lordship. Annexure E, page number 32.
32.
Yes, your lord. And especially in specific direction in page number 35. Give the further orders as an interim measure that treasury of some
What has happened to the repetition?
this repetition has earlier directed authority to
No, is it pending or disposed of?
earlier dispose of, and
When?
direction was given to the authority.
By which order?
Page number 44, Annexure J. Page number 44, Annexure J. Direction,
Yeah,
page
after
number
this, what
49.
happened? After this, what happened?
After this, your lordship, the authority has passed an order.
After this, what happened?
Page 54.
54. 54. Annexure L. Subject action taken, report in compliance of the direction of Honorable High Court in its order dated so passed in the WPC number so madam. With reference to the subject cited above, I would like to inform you that the Honorable Gauhati High Court, Gauhati, while disposing the above noted petition, has made following observation in its order dated 25/6/25, which is appended below. Kuta, the petitioner number 2 and 3, being the minor daughter, are certainly entitled to get family pension and other retirement benefit. The authorities will forthwith take up the matter and call upon the petitioner number 2, 3, and 4 furnish the necessary document. Thereafter, proceed the matter by apportioning family pension and other retired benefit amount amongst the present petitioner number 2, 3, and 4, as well as the respondent number 9. And her
Who is appearing for the respondent present private first wife?
first wife, lordship, Learned Counsel Mr. Soikia, probably he is not present. Earlier, present, 2 times direction.
Huh?
Occasion, he was directed to file an affidavit, but he did not file. But the
Now this
authority,
5,000 you have not received.
no single amount has been, I have received, your lordship. Then the first wife has received the entire pensionary benefit as well as gratuity, DPF, all retail benefit, lordship. By considering the fact that, your lordship, by obtaining legal hair certificate, wherein at that our age
All right, then you
was
file your
showing
affidavit.
as a
File
majority.
your affidavit. Third council for party, the state council submits the instructions that come like you file an where let the affidavit be filed within 3 weeks. Private respondent is also permitted to file their affidavit and apprise the court on the next date as to whether the amount of is 5,000 per month.
No, I'm not inclined to getting 5,000 rupees. That is, the authority has
As recorded. Order dated 4/10/2025, required to be paid by respondent number. Respondent number 12 has been paid. Children of the second wife.
Your lordship, I have an objection, lordship. This observation has only made out by the authority itself, only on considering the submission made by the first wife. So it is well aware that your lordship judgment is also covered, even also full bench judgment. The 50% of salary entitled to get as pensionary benefit by the minor children or either unmarried daughter, outcome of the second marriage, your lordship.
We want to find out whether this amount as recorded has been paid or not.
Absolutely, your lordship.
You have not
then
received
I
it.
may continue. 50%
You have not
your
received.
Yes.
Have you received that 5,000?
No, no 5,000, no single amount I have.
Alright. Release this
Interim order
matter
may be continue earlier.
again on 31st. Interim orders passed earlier will continue. Not 31st, let it come on 7th of August. 7th August.
File this petition lordship for restoration of the WBC lordship 6613 of 2016 lordship, which was dismissed on 29th January 2026 for non-prosecution.
What is the subject matter of the writ petition?
The petitioner lordship applied for the post of GB Constable lordship.
Huh?
Applied for the post of lordship Constable GB lordship in BSF, CRPF, SIF, CISF, ITBC, SSB, NIA, and SSS, and Rifleman lordship. Lordship has qualified written examination and also physical examination lordship. But lordship in the medical examination lordship, his candidature was rejected, saying that he has vitiligo 3:1 in his right forearm lordship. Then lordship, he has examined him before a specialist doctor in the 11th field in CMCH lordship, that is a dermatologist. But lordship, the dermatologist lordship issued a certificate that deformity is not vitiligo lordship. It is a nevus deepictus which is present since the birth of the petitioner lordship. So lordship is that is either a birthmark lordship which is present in the forearm of the petitioner lordship. But lordship, his candidature was rejected by the board lordship, saying that was vitiligo lordship.
You are the newly engaged counsel.
Yes, lordship.
When were you engaged?
So, lordship, on 11th of February, lordship, we applied for the certified copy on 12th of April and filed this on 17th.
Where is the NOC?
Lordship, NOC is in page number 23, lordship. It was issued on
Then-
21st August.
That was on August 25.
Yes, Lordship.
Then
Lordship. The
he was
petitioner
not,
is looking for,
Does it take that long for him to find a lawyer?
petitioner is looking for new counsel, Lordship.
Does it take that long?
Lordship,
6
he
months,
received by Lordship, so it
whatever it
was
may be.
bit difficult for.
Yes.
Lordship, here other two writ petitions, that is a common order. But this is a common order of 3 writ petitions total, but
You are
in
appealing
the
for
other
all the
2
three?
writ petitions,
The petitioner of the 6613 Lordship, he approached us, Lordship, so filed a restoration for that.
What do you say on the merits?
pleadings are complete, were completed, it was listed for top of the list. Earlier, Honorable Justice R. Muzumdar was there for the petition.
This is a selection of which year?
In 2016.
2016.
What remains now? Assuming we allow the writ petition, do you want to go back to the selection of 2016?
No, Lordship, but Lordship, the petition, all the respondents all have already filed their application.
Maybe.
So the
What are
matter
you
is in
what are you
last
telling?
stage.
Where is the writ petition? What remains now in 2016 matter?
Lordship, kindly restore the matter, Lordship.
No,
You
no,
look at
restoring,
Lordship.
what is the point in restoring to dismiss it again?
Lordship, but
No, we have already decided 2016 matter, nothing remains here.
Lordship, the matter was.
You tell
not
me
yet-
that 2016 matter, you still have a case, there is some interim order protecting the appointment of the, or keeping one post vacant, something. 2016 selection is gone by, these people have moved ahead.
Lordship, in
They
the
may have been
W-
promoted also.
Lordship, in the WPC, Lordship, they earlier said of advocates, Lordship, they have prayed for reconstitution of the medical board, Lordship.
May have constitution, but what is the effect of that? This is a selection pertaining to for which year? Advertisement of 2015. Then
2015 January.
findings of the medical board of 2016. Review
Lordship,
medical
there is
board
no fault in the
2016.
petitioner side, Lordship. But Lordship, there is no fault in the petitioner side, Lordship.
There is no
must
fault,
not
but
be
the fact
negative,
is that there is a delay.
But Lordship, kindly restore, Lordship, after that, one order.
Why should we go for the 2 steps? We'll do it at 1 step. We'll not restore and dismiss your petition on the ground of being infractuous. What is there? What assuming there is a direction given 2016 matter, whether any posts are available.
Lordship, there is Lordship, where Lordship, the court has ordered to reconstitute the medical board.
Show
Lordship.
us,
So we want the hearing.
show us. Where are the judgments? Show us. You come back after vacation, show us.
Okay, Lordship.
This IA has been filed seeking restoration of WPC so and so, which came to be dismissed by order dated 29/1/2026 for non-proceedings. Where are the, not IMC, this case.
Upon perusal of the pleadings, upon perusal of the case record of WPC 6613 of 2016, see that the challenge in this writ petition is the action of the petitioner on medical ground, pursuant to during the process of selection of Constable GD, pursuant to the advertisement issued by the recruitment board for the year the recruitment board by the advertisement dated 24/1/2015. Stop the rejection of the medical board was on 27/5/2016, and the findings of the review medical board was dated 6/9/2016. So the petitioner's case was rejected by the medical board on the ground of physical deformity. So this is the challenge made in the writ petition. So, matter was notice in the matter was issued as far back as 23/11/2016. Next date of listing in the matter was in the year 2019 and subsequently 2021 and thereafter 2022. It appears that the matter has been listed after long gaps. There is no explanation as to whether the matter was pursued in the right earnest by the petitioners. At this stage, even if the writ petition is allowed, interfering with the medical findings or remanding the matter for a fresh decision, the question would be whether the vacancies are available for recruitment of it or appointment of the petitioner in terms of the advertisement dated 24/2015. So, prima facie, the court is not inclined to restore the matter, as it appears to the court that it can be passed at this stage. The counsel for the petitioner, however, submits that she would like to persuade the court by referring to certain judgments which she would like to place before the court. Accordingly, release this matter in the month of August on a date to be fixed by the registrar for order. Mr. Mehdi appears for
All
union.
Last of the notice was issued and directed to obtain instructions to whether any vacancies were available. As per our.
Lordship, we may grant some more time, your lordship.
Counsel for the respondent prays for further time to obtain instructions as to availability of vacancy or vacancy either of Hindi teachers.
Yes.
State of Assam.
The district of Bongaigaon.
In the district of Bongaigaon at the relevant point in time. The counsel for the respondent prays for further time. Released again after 3 weeks.
But in the first list, for a standing counsel elementary may be shown, my lord. The vacancy has to furnished by the elementary.
Is elementary, she is appearing for elementary.
No, your lordship, I'm
Oh.
paying for the second verification.
The names of the standing council elementary education reflected in the court by the registrar.
Apply.
As per the office note dated 17/6/26, average service report on the respondent.
You were asked to take dusty steps.
Lord, we are appearing on behalf of all the respondents.
All.
Lord, we have received the papers yesterday only. So let us have some time to file the counter. Let it come after 2 weeks.
Mr. A.R. Tobildar appears for the petitioner. Mr. S. Doctor, senior counsel, assisted by Mr. S. Doctor, appears for all the respondents.
All the respondents.
Submitted that the instructions have been received. They would like to bring it on record by way of an affidavit.
Well.
The respondents pray for 2 weeks.
2 weeks.
Right. Therefore, the matter be listed immediately after reopening the month of July.
Can a date be?
Yes, 17th July.
Obliged.
Interim order, if any, will continue to the next day of listing.
Obliged.
Yes, that affidavit is ready, Lordship. I will file it next week.
Huh?
I will file it next week, Lordship, immediately after vacation it may be taken.
There is some interim order, no?
No.
Ms. R. Devi learned CGC prays for further time to complete instructions and file necessary affidavit. She prays, she submits it, the matter be listed on.
After vacation, Lordship.
Be listed immediately after vacation. Mr. K.R. Patgiri appears for the writ petition. List 27th July.
Obliged.
May I please, Your Honor, the non-payment of pension, I have received my pension, but suspension period has not been regularized as of today. So there was a specific direction beyond our board.
Lordship, this regard, department has already sent the instruction that file was endorsed to the judicial department, and judicial department observed that in compliance of the order of this honorable court, the proposal for regularization of suspension period for pension purpose only appears to be justified. Accordingly, file endorsed to the higher authority for appraisal and obtain instruction, Lordship. So as ministry has already changed, for a few days may be allowed for appraisal, Lordship. Judicial department has already.
Mr. P. Kotoki, senior counsel, assisted by Ms. Sunsu and Kashyap, and Ms. M.M. Kotoki appears for the veterinary department. So, Ms. Kotoki submits that the department is presently undertaking the process of passing appropriate orders in compliance with the directions of the court. ID judgment and order.
Order 25/11/2022.
25/11.
2022, WPC number 1476 of
2022 in terms of WPC number
1476
1476
of 2022.
of 22. So it is submitted that the endorsement of the judicial department that the period of suspension regularized has also been received in favor of the petitioner. Therefore, the steps are undertaken to pass appropriate orders. That's what you're saying. Considering the submissions made, bringing this matter again on 24th July. 24th July? 24th.
Obliged.
Another part of it, non-release of pension value as well as
It was sent for mediation. What happened? Failed.
my lord. Petition is paid, my lord. Subsequently, my lord, the government court has finished gave them to file a certificate of petition, my lord. They have not yet filed, my lord. What they have sought for, my lord, they have sought for recovery of, my lord, overstay, my lord.
You have not filed affidavit. See, why don't you file? You don't even settle the matter in mediation.
The instruction is confusing, my lord, that's why.
Huh?
Instructions are confusing, my lord.
Then you go for mediation again. Settle it. You are referring to mediation again.
My lord, that was we are there, but the government, my lord, was not cooperating. They have had a
But the affidavit can be filed only upon instructions being available. No instructions are there. So what is the point? What is the claim of the petitioner?
Yes, sought to cover, my lord, or
Recover.
yes, my lord, face 32, my lord. And I said, my lord.
32. Excess amount.
Yes, yes.
This excess amount is for what?
For, my lord, overstay period.
Overstay.
Yes. Now, they are allowed to continue, my lord, get staff there, my lord, for 6 months,
And it is
8
stated,
months, my lord.
and it is stated that my lord petitioner has submitted his entry report, my lord, in another division instead of his parent division, my lord, that's why. the
So you
court-
bring all this in affidavit. Why
Yes,
are you
my
not
lord.
filing the affidavit?
It is confusing, my lord, that's why.
Huh?
I pray for 2 weeks time, my lord.
All right. Mr. S. Hawk for the petitioner, MSD now for the irrigation department. She renews the prayer for filing affidavits. Prayer made in without this matter after 2 weeks. MS H. Sharma for the accountant general. 2 weeks.
This is appointment of arbitrator, my lord. My letter sent out the list of
Lordship, department had given me a list of arbitrator if, and I have shown him.
Not acceptable to us. Because your turn for appointing arbitrator is gone after the notices are issued. You could have appointed then. Where is the agreement?
My lord, arbitration is clause, my lord, page 34C, my lord.
Hmm. 70.
17.
Third learned accountant for partners. This application is filed under section 11. 11.4. 11.6.
11.6 should
The post title says 11.4. 11.6. Seeking appointment of an arbitrator. In view of the disputes which had arisen by and between the parties. Petitioner was issued a work order. Where is the work order?
work order. Annex 1, my lord. Page 20. The widening of road, my lord.
By the respondent authorities. For the work is number 23, Chailovo in bold. Denmark Korazan. Agreement was also by and between the parties. As per the agreement, in case of any dispute, as per clause 70, disputes will be referred to arbitration. So, work was terminated because of inability of the petitioner to carry out the work within the prescribed time. The work was terminated. This led to certain disputes in respect of the claims raised by the petitioners. So, there is a notice.
Notice is my lord, page 35.
The petitioner issued notice dated 5/5/2025, calling upon the respondents to settle the disputes, and when the same are not settled within the period specified, the matter will be referred to arbitration. What was the reply by the respondents?
No reply.
The respondents did not furnish any reply, nor was any arbitrator appointed. Stop the petitioner is therefore filed a petition, the arbitration petition on section 11(6) for appointment of an arbitration panel. M.S. Sharma, learned CGC. Instruction submits that the army,
Lord.
the respondent army authorities have submitted a list of arbitrators, which they choose, from which the court may, they are all army officers.
I
No,
think
just-
on BD Agarwal.
Justice B.D. Agarwal is also in this.
Okay. Whether his name is there or not.
There, my lord.
Huh?
Oh, that list
That
not there, my
list-
lord. But they provided the list, my lord, in there the name is there.
You have no difficulty.
No difference.
Where names of some prospective arbitrators are listed. So, see list forwarded. Justice B.D. Agarwal, former judge, Gauhati. So reflected in the list. So, suggested names for the appointment of an arbitrator. So, Mr. A. Roy, learned counsel, not only submits that they have no objection to the court appoints Justice B.D. Agarwal, former judge. Although pursuant to issuance of notice under section 21 and issuance of in the under the arbitration petition filed by the petitioner, ordinarily the respondents lose their power to refer or choose their arbitrator. The fact that the name suggested by the respondents being a former judge of this court and the same being not objected to by the petitioner, this court will agree that the matter may be decided through arbitration as agreed to by and between the parties. By the agreement executed, they can still sue. There are Justice B.D. Agarwal, former judge, the number of to the judge to be appointed. Side disputes arising by and between the parties, arising out of the agreement number so and so, dated so and so, please furnish the number, date of the agreement and the page number. The prospective arbitrator will now require to furnish written declaration under section 12(1) of the Application and Constitution Act of 1996. Stop in the event such a written declaration is received, the appointment made by this court, ID this order will be confirmed on the district. Take a copy of this order, communicated, still be available by the registry of the court. Parties are also at liberty to place a copy of this order. Internet prospective matter. Release this matter again on 15th of July.
Yes.
Obliged. Petitioner approached the honorable court challenging the transfer order from Gauhati to Patna. The authorities had rejected it on the ground that his son is lordship 80% disabled, mentally retarded. He didn't have the disability certificate issued by the competent authority. So now he has obtained it. In the meantime, they have lordship cancelled my transfer order. Also cancelled.
Then
Nothing.
We close it.
Lordship, but lordship, my now contention is that lordship that this is the certificate now we have obtained, and the authorities has written that the since he is 3 years old, so the actual certificate will be given after 5 years. Lordship. After attaining 5 years of the the child. So lordship, now they are intending to transfer me immediately after withdrawing this order. Is that intending to transfer without considering the OM? The OM is at page 71. Lordship. It categorically said that mentally retarded 3 years old son, lordship, both parents are.
where is the OM?
Lordship, OM, yes, lordship. OM is at page 41. Lordship. Page 41 plus 3. And the disease is specifically mentioned here. Clause 3, may I read subclause 1 and 2? May I read, lordship?
Yes.
Subclause 1 says, lordship, a government employee who is a caregiver of dependent daughter, son, parents, spouse, brother, sister with a specified disability, as certified by the certifying authority as a person with benchmark disability as defined under section 2R of the Rights of Persons with Disability Act 2006, may be exempted from routine exercise of transfer, professional transfer subject to the administrative constraints. Then lordship, next clause is also very much important. The term specified disability as defined in the schedule to the Rights of Persons with Disability Act 2016 covers locomotor disability including leprosy, cured person, cerebral palsy, dwarfism, muscular dystrophy, so and so, and at 6 lordship, Roman 6, speech and language disability. And his son lordship, as per the certificate, A as the global that disability lordship 80%, that is the mentally retarded lordship, and both the parents are lordship working. So my humble submission, lordship, that if they transfer also, they should consider my that certificate, and if possible, lordship, in the northeastern region itself, because he can at least take care of the 3 years, because the family is suffering. All the family members are
You
behind.
show us from the Disability Act,
No.
what are the parameters necessary to be considered for transfer? Is there any specification?
Yes, they have mentioned this here, lordship,
Where?
in the OM itself.
Oh.
This OM has been lordship issued in terms
Now
of
the
the
question is whether he suffers from speech and language disability.
yes, that is the ASD, that the global, that is the speech and language. The mental retardation, he cannot speak also, and constant attendance. That 3-year-old lordship. Now he is 4-year-old.
Yes, you consider.
Lordship, now it has been cancelled. If it is, it will consider as per law.
As per the OM,
As per
that
OM
also
and
we
the
say yes.
certificate.
No, the transfer order is cancelled.
Cancelled.
Come before the court challenging the transfer order.
Yes, that is
That is
cancelled.
cancelled, so there is no
No,
cause
my-
to urge. Now your apprehension that you may again be transferred.
They will transfer, not only apprehension, because they are now saying the order itself, the cancellation order itself, that doesn't reflect that it is, they have considered my certificate. Initially, lordship may, in the honorable court has directed at page 67 of the petition that considered a disability. Page 67, honorable court's direction, our court's direction.
Where is your name here?
At that, it was new.
At backside, lordship.
Backside.
That is
Point
Due
two.
to, point two, that is administrative exigency, not considering my lordship son's health condition.
Is your name mentioned here?
No,
This was the
backside, second,
3626.
lordship.
yeah, backside.
Point
two.
number two.
Point number two.
My name is mentioned.
Sir, cancel the earlier post.
Yes,
Yes.
due to administrative exigency, they have not taken, because earlier they have rejected my case, saying that I didn't have the.
You want an order from them that you shall never be transferred.
No, I am not saying that.
Then what are you saying?
I am saying that observation is required, that when they transfer me, they consider, they should consider the when they.
Counsel for the party will petition filed with the petitioner challenging the transfer order at page
At page 46 now.
transfer
My
the
name is
order
applied.
at page 46,
46.
26-7,
26.
24, serial number 9.
Right.
Petitioner is serving as research officer under the Department of Central Water Commission, Ministry of Jal Shakti. Is transferred from Gauhati to Patna. So, petitioner is agitated before the court that he is the caregiver of a disabled child, intellectually disabled child. He is 3 years old, 3 to 4 years old. The authorities did not take that into account and accordingly rejected his representation. So, this court had issued notice and was granted interim orders by order dated 24/1/2025 and
Directing to produce the certificate.
huh?
Directing, there was a direction to produce the disability certificate. I have to.
And the petitioner was permitted to produce the disability certificate. The petitioner has placed the disability certificate issued by the senior medical officer, Office of the Joint Director, Health Services, Kamrup, Gauhati, where his son, what is his name?
Ayan.
Ayan, IAIAN. Huh? Son's name, who's shown to be aged about 3 years, is shown to be
Zayan Borman.
JAIN.
ZIAN.
I don't know, it is written here as JAIN.
Yes, okay. ZAIAN. Zayan Borman.
He is suffering from where the provisional diagnosis in respect of his son is within bracket global developmental delay in bracket ESD, which is shown to be 80%. And it is also shown that disability certification to be done at the age of 5 years, since he is only 3 years now. So, the learned counsel for the petitioner has also placed before the court the order dated 3/6/2026, whereby the appropriate authority has recommended to cancel the earlier transfer and posting order of the petition. So, that view of the matter, nothing surviving the writ petitioner. The petition accordingly stands dismissed as in purpose, interim order will stand vacated. Pending ayes are also dismissed. There are needless to say. Then if the authorities contemplate to transfer the petitioner, then the appropriate due consideration be given. When? Where is the when?
When is at lordship? Page 70. There's 41. Page 40.
OM dated 8th of October 2018, which provides for
exemption from caregiver of dependent children who are suffering from specified disability within quotes.
And
Comma, and also keeping in view the rights of persons with disability Act 2016. Retribution accordingly closed.
the certificate also maybe that may be because that is not with them. In terms of the court's order, we have produced that certificate.
So what do you want?
So that may be also in taking into account of the certificate also, because they are again going to say 5 years, you will receive after 5 years now. So that may be also.
Copies of the cancellation order or transfer order, as well as the certificate. Medical certificate issued in respect of the son of the writ petitioner is kept as a part of the report. The authorities will also consider the certificate issued by senior medical officer dated 5/3/2025, while taking into account the condition of this, well, taking into account the care required to be given to the child of the writ petitioner because of the disability he suffers.
Obliged.
Pursuant to the last order dated 16/7/2025, passed by this honorable court, the parties have successfully undergone mediation and the dispute stands resolved, Your Lordship. However, despite the successful mediation, the pension benefits have not yet been released, Your Lordship. Therefore,
You said it is, you say it is successful.
yes,
Successful then after that also.
No, no, but the report says it is not successful.
we got the instruction from senior counsel that the mediation has been successful.
It is there, mediation did not yield successful outcome. Yes, Mr.
Lordship, regarding the matter, Lordship, this mediation part, Lordship, today I cannot say, but otherwise, Lordship, we have received one prayers comment. And here the petitioner Bani Basumatari has shown, Lordship, is not a next of kin of the deceased, Lordship. Next of kin of the deceased, the names are different. He has two daughters, Janita Basumatari and Moni Basumatari, but Moni Basumatari is not his daughter.
Have a certificate issued by the Gauhati annexed as Annexure 4 in page 17 and Annexure 5, page 19 and 20, Your Lordship.
Anita Basumatari. Who is Anita Basumatari?
Lordship, Anita Basumatari is the other unmarried daughter of the deceased, Your Lord. But the petitioner, namely Mani Basumatari, is the unmarried pendant daughter, Your Lord.
Who come to page number 17. Who is, what is this? Is it a certificate or what?
Yes, Your Lordship.
What certificate?
This certificate is a certificate by the Gampura stating that the petitioner Bani Basumatari is an autistic lady and the rest of the legal heirs, Your Lordship, stating the names of the rest of the.
This is by the Gampura.
Yes, Your Lordship.
Why have you not applied for the next of kin certificate?
Your Lordship, the certificate has been applied for it, but it has not yet been received.
Huh?
It has been supplied. It has been applied for, but it's not yet been received.
Where is your application? Is it enclosed here? Huh? No. Then when did you apply? Writ petitioner claims to be an unmarried daughter or late Nogendra Kumar Basumatari, who was serving under the Assam police. Stop. The father of the petitioners claim that Nogendra Basumatari was their father, who expired on 3/9/1997. Stop. Thereafter, after the expiring of his father, family pension was granted in favor of the mother, namely Nimeshwari Basumatari. Stop. The mother of the petitioner also expired on 15/11/2020. And thereafter, the petitioner, being an unmarried daughter, along with her sister Anita Basumatari, are entitled, who is also unmarried, are entitled to a share of the pensionary benefits. So it is stated that the petitioner is an autistic person. However, the claims made by the petitioner are not entertained by the respondents. So petitioner has referred to certificate stated to have been issued by the Gamuda of which village?
Raibari, Your Lordship.
Where does one find it?
Page 19, Your Lordship, 19 and 20.
19. Gamuda of village Dayabari, post office Pukraja. Stop. A representation was also issued to the superintendent of police Dhuri to release the pensionary benefits. Stop. There are Mr. C.K.S. Bulwa on the other hand, submits that as per the records, father of the stated that as per the claim of the petitioner, the father, namely Nogendra Kumar Basumatari, during his service, had entered following particulars at the time of his retirement in his service book. He has under Namketa Liribai. Stop. Since the names of the petitioner or her sisters are not reflected as nominee, the respondents are unable to redress the claims made by the petitioner. So, the counsel for the petitioner on a pointed query by the court as to why the next of kin certificate has not been enclosed to the petition. The counsel submits that the next of kin, although applied before the concerned circle officer, the same has not been issued. Stop. However, copies of the application or any representation filed before the circle officer is not enclosed to the writ petition. So, under such circumstances, there being no material to show that Nogendra Kumar Basumatari is the late father of the petitioner and her sister Anita Basumatari. There are no material for the before the court to issue any specific directions to the respondent. Prayer made therefore in the writ petition therefore stands declined. However, the respondents are at liberty to pursue their claims before the circle officer for issuance of a proper next of kin certificate. If such a certificate is received by the petitioner, then the petitioners may proceed to stake their claim before the authorities. With the above observation, writ petition stands closed.
Awesome.
Mr. Mehdi appears for respondent number 5.
Possible.
Are you at a fraction doesn't order?
But please, that's see the last order, let's say. Have the order which is covered. Already coordinated mentioned passed the order. Service period rendered as a Anganwadi worker that is counted for pensionary benefit as a qualifying service.
Pensionary benefit. She is serving as what?
Supervisor Lordship.
Supervisor.
Lordship. She
Is
retired.
it a pensionable post?
She retired in the year
Is it a
2022.
pensionable post?
Yes, Lordship.
Yes.
And now her
Respondent, what do you
service
say?
is Lordship counted under the NPS scheme, Lordship. Therefore, Lordship, this order Lordship says that the
How many
period
years have you put in?
since 1995, more
No.
than 30 years.
As a supervisor? how many
7 years, Lordship.
Huh?
More than 7 years.
7.
Because I was promoted in the year 2014, 10, 12, 2014, page 30.
Yes, who's for the respondents? Anganwadi.
Karbi Anglong.
We'll call for the Karbi Anglong Standing Council. Yes. Have you gone through the orders?
Lordship, instructions are awaited, but the similar matter has been disposed of by the coordinating bench.
What is the number?
7299/2025.
7299. Purnima Dhar.
Lordship.
Head council for party disposed. Ms. Kemprai for Karbi Anglong, DD Burman for state. Mr. Chakraborty for
Respondent number 7.
respondent 7. Huh? Director of pension is? Oh. Mr. Deka for the. Yes.
My last order, my lord, I have been asked to, my lord, for this relation rule, my lord. Familiar, my lord, my lord. As per rule 23, my lord, the state system, my lord.
What rule?
My lord, Assam medical attendance rule 2008.
Rule.
Rule 23, my lord. Procedure for sanction of royal and medical reimbursement.
Yes.
But in terms of this rule, my lord, we have submitted our application, along with all relevant documents, and thereafter, my lord, the medical admissibility board, my lord, sanctioned an amount of rupees 26,400 to resume. My lord, admissibility board, my lord.
Please read the rule properly.
Yes. A government servant as defined in these rules
While submitting a claim for reimbursement of medical bill, the respective administrative department shall furnish the following documents information along with bill to this administrative department through the respective drawing and disbursing officer, controlling officer. Number one, authorized medical attendance recommendation of the referral medical board where applicable, the approval of the Director of Health Services Assam where applicable, essentiality certificate to be issued by the authorized medical attendants, record of the referral hospital, private hospital, final bill issued by the hospital authority at the time of discharge certificate from the hospital concerned, bank account number of the claimant. Now, B method. Administrative department, while issuing sanction of the reimbursement of the medical bill, shall issue a prescribed advice slip duly filled in with signature and seal of the concerned treasury officer under seal cover. The advice slip shall be supplied by the finance department, the treasury officer.
So now you have given the certificate.
Sanction has been granted, my lord, by the divisional forest.
Where is the sanction order?
I have, my lord, just
This is only a certificate, not a sanction order.
there is another order, my lord, on the other side. Communication to PCCF that compliances are fulfilled.
Is it enough to sanction? Where is the sanction order? You have issued a certificate for non-receipt of medical reimbursement. The amount has not been sanctioned.
The certificate, my lord, so far just yesterday it was, my lord, issued. After that, my lord, I have been informed that the sanction process will be done. So, my lord, may fix it. After vacation, I will.
We'll fix it, but we'll ensure that if it is not done, then it will levy interest at bank rates to be recovered from the hearing officer. Making it clear. Unless you say that it was because of the fault of the writ petitioner that the sanction could not be done. When did you submit your bills?
My lord.
When did you submit your claim?
My lord, I submitted claim, my lord, way back in the year, my lord, 2018, my lord.
Then 2018 claim you are sanctioning. Why this delay?
It was pending with the referral board for a long time, my lord. So that is why petitioner had to ultimately approach this honorable court. After petitioner approached honorable court, my lord, we have been.
What is the referral board?
Medical referral board, my lord. They have to forward his case.
Heard the claim of the writ petitioner is for release of reimbursement of medical bill was submitted by the petitioner for undertaking medical treatment. Stop. Claim submitted by. Where is the claim?
My lord, claim petition is not there, my lord, but the letter issued by the respondent number 3 is, my lord, it's the, my lord, administrative head, my lord.
Page number.
Page number, my lord, 14, my lord. This letter issued by the divisional forest officer, my lord, after, my lord.
For the medical treatment undergone for the period 7/5/2017 to 23/5/2017. So, thereafter, the claims made by the writ petitioner has not been raised. Several opportunities were granted by the court. Whether today on the matter is hold up, Mr. I. Botagur has placed before the court a certificate dated 18/6/2026 issued by the DFO, Dhubri Forest Division, certifying that no medical reimbursement has been claimed, has been sanctioned to the office in respect of petitioner or from any other sources. So, this communication subsequently, the DFO has also communicated before the PCCF and the head of Forest Force. Certificate of non-receipt of medical reimbursement from other sources. Whereas the learned Forest Council for the Forest submits that the the matter is under process and pays for 2 weeks for the time. Payment is allowed, permitting the respondents to process the claims of medical reimbursements expeditiously. So the status be updated, be apprised to the court in the next returnable date, released on 17th of July.
Okay.
Space matter. Now, can you? Last question and also hard this matter. You course of my service, my wife name as a nominee, the record itself. And that marriage, my lord, actually was resolved in the March earlier, 1982. That is on 19. Only reason, my lord, one daughter was born, my lord, and while issuing.
Yes, Accountant General, yes. What
We
instructions?
have forwarded one reminder letter to the PHE department on 16th of June. We are yet to receive the pension proposal.
Yes.
But in page 40 of the petition, my lord, they have returned the proposal.
So you have to resend it after
Resubmit.
meeting the queries.
I will, my lord, take instruction if we have a response. Very much. If sometimes.
They are asking you, page 40, they are asking you certain queries. Why have you not responded to that?
I will, I've got instructions, my lord, I'm just praying for a week's time. After vacation,
The proposal of the writ petitioners, pension proposal of the writ petitioner, who claims to be the second wife of late Abdul Khalik, who was serving as an ex-pump operator under the Department of Public Health Engineering, was returned by the Accountant General's office as far back as 18 September 2024. So, state communication, certain queries were raised as to the whereabouts of the first wife and as to whether the second marriage was solemnized after the death of the first wife, and a copy of the certificate, death certificate, the first wife, as also the copy of the marriage certificate, etc., were sought for by the Accountant General's office. Similar communication was issued on 28 May 2025. So, today when the matter is called up, Mr. I. Bothakur submits that he has no instructions whether the say queries have been met and the proposal has been returned back to the Accountant General's office. So, where it is not understood why the queries raised by the Accountant General's office are not met by the administrative department, which is the PHE department, in order for the claims to be processed by the PHE department regarding the family pension proposal of the writ petitioner. Stop. The matter be relisted again on 15th of July, by which time the PHE should apprise the court as to the status of the, as to whether the queries raised by the Accountant General have been met and the proposal has been resent. If even no instructions come, then consequential orders may be issued by the court.
Lordship, I have the instruction of 16 June, Lordship, pension copy.
What is that?
Lordship, we have requested the Executive Engineer Public Health, Lordship, to forward the pension proposal in terms of order of this court.
So that earlier order.
Yes, Lordship. Please.
The same thing, that page number 40-41.
Yes, Lordship.
My humble submission, my lord, everything put a lordship, and they are unnecessary because at that time, my lord, I was a casual employee, the year 1980. That marriage was even 1980. that person was died, my lord. All children, my lord, filed NOCs with an affidavit. There is
Let
nothing
them
to, my
answer
lord.
the queries. Let them answer the queries. Where is the marriage certificate? Where is the death certificate? Marriage certificate are they all included here?
Yes, my lord. Death certificate, my lord, page 42, my lord.
Death certificate.
Page 42.
This is the first wife.
First one.
Then marriage certificate, your marriage certificate.
My marriage certificate, my lord. My lord, page 28.
The death certificate of late Abdul Khalik is enclosed as Annexure 2. The death certificate of the first wife, Neo
Annexure
Yarun Nessa Begum, is enclosed as Annexure 13 to the writ petition. The marriage certificate is also enclosed as
Annexure 4, my lord. Annexure 4 and, my lord, Annexure 5, which is, my lord, which is issued by the, my lord.
This is not marriage certificate.
This is not marriage certificate, but during the course of inquiry at the time of filing NRC matter, that issue is issued by the.
No, is the marriage certificate there or
is
not?
Page 28. This is a Kabin now.
28. The Kabin Nama in respect of the
Annexure 4.
marriage of the writ petitioner with late Abdul Khalik is also
And
enclosed.
Annexure 5 name also may noted, my lord. This is the certificate issued by the authority, my lord. The secretary countersigned by the BDO. Annexure 5, my lord. That is done, my lord, after inquiry. It's 32.
Certificate of the Secretary Gandhai Gaon Panchayat, the district of Karimganj, is also enclosed as Annexure 5 to the writ petition. There it is stated that the petitioner was married on 18/7/1990 with Abdul Khalik. And are residents of
Address.
what is the address?
Address husband address Dit Potoroshi
Dit Potorashi
under
village,
North Karimganj development.
under North Karimganj, revenue circle of Karimganj district. So the next of kin certificate issued by the concerned circle officer dated 26/6/2020 is also enclosed. Under such circumstances, the respondents will reprise the court as directed the next day.
Here, your lordship, no extra copies have been furnished to us.
Counsel for the petitioner submits that the extra copies will be furnished within 3 working days. Mr. D. Bora appears for the respondent, released after 3 weeks.
I'm paying for some time to find my affidavit. Well, in this case, whatever I know, here, the petitioner one is the physically handicapped candidate, and in the similar situation, another case is pending before your lordship. In that case, they have filed the affidavit. In that affidavit, they have stated that there is no way APA in the written examination in that particular post.
There is?
According to kindly peruse my additional affidavit, that is additional affidavit, page 45. And paragraph 4, second paragraph. It is relevant to mention here that two posts earmarked for the PWA, PWB category. However, no applicant under PWA and B category appear in the written examination. Whereas, the petitioner number 1 in the present case, he is the category of B. And he was appeared in the examination, but he has not been considered. Where this statement has been made in the other cases, not in this case, my lord. Therefore, my lord, let them take the instruction in that particular point, my lord. Whether he
The Mr. D. Varwa for the petitioner and Mr. D. Upamanu, standing counsel, Mr. Upamanu, prays for further time to complete his instructions. Released after 3 weeks.
okay. All right,
Here, your lordship, we have sent the affidavit for vetting yesterday. The matter will be described immediately after vacation.
Time. 3 weeks time. In February, 3 weeks time, it is granted for filing.
We have sent it for vetting yesterday, so some time. In the meantime, we
Mr.
will
M.
vet it.
Sharma appears for the writ petitioner. Mr. D. Bora, State Counsel, renews his prayer for further time to complete his instruction. He submits that the affidavit is in the process of being filed. He prays for 2 weeks further time. 2 weeks further time. Released.
July 22nd.
Release this matter again on 22nd.
Lords, I appear in item 35, my lords. Or there's a section 11 petition, one of the last 2 dates, my lord, the railways have been taking time to file reply.
I pray for some time to file it.
Lord, they have been taking time, it's been last 2 dates,
I
my
have
lord.
not received instruction otherwise.
It's a purely, my lord's, arbitrable dispute, which they also admit. It's a section 11 petition.
We
my
have
lords,
not
for
admitted lordship, even lordship, some written instruction I have received lordship, they have not even claimed it. Lordship. I will place it by way of affidavit.
How much time you want?
After 2 weeks, lordship, after vacation.
All right.
My lords may, if my lords may permit me to make a submission, my lords may grant them last opportunity, my lords, so that it can be argued, my lords, on the next date.
I heard Mr. Swanso, learned counsel, who appears to the court through virtual mode, and Mr. K. Gogoi, learned CPC for the respondents. The respondents pray for further time to complete their instructions and file objections. The counsel for the petitioner submits that sufficient time has been granted earlier. Therefore, may be considered to be the last chance for filing the affidavit. Considering the prayers made, release this matter again on 24th.
We commencing from 27 lordship.
Why so much of time?
Lordship, probably I will be not there last 2 weeks. Lordship.
Your objection. You are filing objections.
Okay. Any date after vacation?
Mr. Sanjay Sharma, petitioner in person, and Mr. CC appears for respondents. Submitted by the learner CCC that they'd like to file their objections. Prays for how much time?
About 2021, any date?
3 weeks time. Is this matter again on 24th? 24th July, 24th.
Problem. Okay, here I pray for some time for obtaining the instruction.
Last order matter.
Not received the instructions.
Court provision.
Yeah, after the vacation. Immediately after the vacation.
Learner CCC uses prayer for further time. Counsel with the petition submits. It's again on 24th July.
Lord.
with regard to non-contributory pension scheme of the
Assam State Textbook Corporation Employees Union. In this case, lots of NOC was obtained by the parent department, that is Education Department. Thereafter, lots of NOC was also obtained from lots of public enterprise, pension, and lots of finance.
In this matter, we have received the instruction, but this instruction is incomplete. Kindly post the matter after vacation, so that we can.
Before civil bench too.
Since the corporation lawsuit, the administrative control is under the elementary division department also. And most of the also this case was.
When can you get it? Instructions,
After vacation,
vacation, but
3 weeks, Lordship.
Mr. Bodavu?
I am for the corporation.
Everything was also finalized, also only during the hand transfer, also the secretary has raised the objection.
The fund is protected.
Fund is protected. And also this NOC was obtained from all the departments, and the pension scheme and the trust was also created also.
Still SK, that's. Education department submits that instructions and all. Mr. Raimond. This matter again. 24. July.
Public.
Lordship, in this case, Lordship, my affidavit is gone for vetting, Lordship.
What are these matters?
Lordship, here recruitment matter, Lordship, but we have challenged the maintainability. Now he had filed an IA for impleting the parties. Earlier he has not filed, in spite of informing. Now he has filed when we have filing our affidavit on the question of maintainability. Lordship, I pray for some time for filing my affidavit because it's done for vetting.
What is the ground you have challenged?
Lordship, in spite of that is qualified in the examination, keeping the post vacant, we have not been that is appointed. So on their request, they have
You're rejected in the medical examination.
all qualified.
All qualified.
All qualified.
Why not appointed after that? Any?
Lordship, that instruction I have, because of the question of maintainability, because they are not.
You're
made-
filing affidavit only on the point of maintainability.
Yes, because Honorable Court has asked us to file because he has not made, in spite of informing him that he has not made a party. Now he had filed, today he has filed an
Not
affidavit.
today, because it has been listed today.
Today. That's
There is an IA listed.
I had listed losses
I-
54 and 55 connected I.
Now he had filed.
We have made all the, that is the nodal officers, because the examination was conducted by Staff Selection Commission.
But the recruitment.
And the examination and result has been declared by Staff Selection Commission. So regional,
Any objections in the IA?
Lordship, now we have objection, Lordship. Let me file our maintainability. Now, in
So
spite
IA is pending.
of IA is filed
Once the
later
IA
on.
is filed,
IA is later on filed for impleting the parties, Lordship.
whatever it may be.
But it is filling up the lacuna, Lordship.
no, repeatedly
Yes,
the
sir.
court has
Lordship,
requested.
kindly see advertisement, in spite of that, he has not made him a party, Lordship. Page 20, Lordship. On the first day, it was pointed out to him. He was adamant that, no, I will argue on that.
No, the maintainability only on the question of non-joint.
Non-gender of necessary part.
That he is seeking cure now.
Now he is filed, Lordship.
Parties
Are-
actually array of party. The names are only one nodal agency is CRPF, but
CRPF.
here they have written nodal officer in all the CAPFs. The parties are not correct.
Lordship, let first question of maintainability.
Because in repeated request by the
Question of
court,
maintainability to be decided only on the ground of non-joint. In the case of pending IA makes no sense. Either you object to the IA by filing your objections that this IA is defective or not permitted or whatever
Lordship,
you want to say.
let me file our objection. to
Then
the time.
otherwise on the ground of affidavit, the point of maintainability, there can be other issues. That the territorial jurisdiction or
On the non-gender of necessary.
only on non-gender. You are seeking to correct it. Unless you have serious objection, like to allow this IA.
But the parties are not
Huh?
not made accordingly.
All right, then issue notice in the IA.
Lodged
Mr. S.S. Roy
in item 39.
appears in IA 39, means 54, 55, IA 2076.
Logic. First one I made.
Vida Colita.
Yes.
For all the respondents or objections may be filed by the next returnable date. The next IA. This is also
Same.
2074.
2074, yes, Lord. Item number.
MSB Sharma appears for respondent. Parties. Objection will be filed by the next returnable date. Matter be listed accordingly on 20 July 20.
All right, okay.
Yes, we have sent the affidavit of vetting, Lordship. Last week we have sent it, Lordship. So, Lordship, 1 week time.
Mr. K. Gugoi standing counsel as per CBC, pray for further week's time. File the affidavit. Mr. Peria.
Yeah.
Counsel appears for the petition of the prayer date. Released again after reopening of the ensuing sum application.
Lordship may kindly fix the date.
20 July.
Much obliged.
Sorry, can it be on, Lordship? Only on 27 also.
Huh?
On 27 also.
27th of?
27th of July also.
You need only 1 week. You are going
No,
to be out.
I will file affidavit, Lordship, by 20, if I am listed on 27.
27 July.
27. Obliged, Lordship.
The petitioner is presently serving as the insurance deputy director in the health department, my lord, the HEM department. I have submitted, my substantial post is technical officer, my lord. I have submitted an application representation before the authorities on the 31/12/2024, praying for my consideration for promotion to the post of deputy director. My lord, it has not been considered till date, my lord. Therefore, I approach this honorable court by way of the instant writ petition, my lord. At this stage, my prayer will be, my lord, to issue a direction to the respondent number 1, consider my representation within a limited time frame.
Yes. Heard Mr. RM data. Serving. You are serving as
Deputy Director of Health Services, within
Deputy
brackets HEB,
Deputy Director of Health Services.
No, he is
H.
as in charge deputy director, my lord.
In
Substantial
charge Deputy Director. Within bracket HEB. and
HEB.
Assam. Petitioner's claim is that he should be considered promotion
the post of deputy director in the
and appointed to the promotion and appointed to the post of Deputy Director on regular basis. Submitted representation before the Director of Health Service. Where is the representation?
My lord, representation I have not annexed, my lord. At page number 29, lordship will find the reference, my lord. In fact, it was submitted before the principal private secretary chief minister, and later it was forwarded to the commissioner secretary.
He submitted the representation. Health. Same is presently pending. Dated 21/1/25.
31/12/2024, my lord. Page 29 reference, my lord.
31/12/2025.
2024.
Which is lying pending. The petitioner is before this court.
Submission of the council petition that is representation and remain unattended. Orders have been passed. And if any orders have been passed, the same has not been served. Prayer before the direction. Secretary.
Yes, please.
Department of Health. Dr. Vasan, consider and dispose of the representation filed by the petitioner which was forwarded by the office of the Chief Minister by the communication dated February 25. So it is submitted that the representation be considered and speaking order passed. So Mr. Pomenu does not object to the prayers made accordingly the petition stands directing the commissioner, Secretary, Department of Health and Welfare, consider the representation prepared by the petitioner and pass appropriate orders. So from the enclosures to the petition, it seems that at the lecture 11, said representation stated to be filed with the petitioner was forwarded to the office of the principal, office of the commissioner and secretary, Department of Health and Family Welfare, and which February 25, which appears to have been received 19 to 20. Department of Health and Family Welfare will consider and pass appropriate orders of the same representation. Appropriate speaking order, same representation. It is to say that if when such an order is passed, copy thereof will be served from the petition and stop. In the event any order that is passed, copy thereof should be served of the petition. The exercise will be completed within a period of 60 days from the date of receipt of a certified copy of this.
This government.
Highly obliged.
I am for the appear for the restaurant number 7. I have to file affidavit of police.
Mr. K. Bonita, council, hearing for respondents.
I also have received instruction, Lordship. I'll be filing the affidavit.
Submits that affidavit required to be filed. Similar prayer is made by Ms. N. Bhattacharya. As doctor also submits that he would like to come to instruction. MS. Council.
And pardon.
Appearing for the petition. Okay. Stayed again after 4 weeks. Yes.
Nothing.
Yes.
My lord, before my friend starts, my lord, just now I have come to know, my lord, the WPTBC is made a party in both the petitions, and I have not served with any copies. My name is not there in the cause disclaimer. Just now I have come to know. From this,
has been served, Lord.
my lord,
Copy has been served, Lord.
my lord, the record is before your lordship. If notice is given, copies served, my signature will be there.
In which matter?
Both, my lord. 52 and 48.
No, my lord.
52, you're not a party.
WPT and BC, my lord. 52, my lord. Respondent number 1, my lord.
52, you're respondent number 1.
WPT and BC.
And
Then second, then director WPT and BC number 6,
42. 40,
1 and 6.
48.
In my lord 52, 1 and 6. And
You have
in,
to serve copies?
in 48, my lord,
No, Lord. Copy has been served, your lordship. I have the receipt copy, your lordship.
Check for you.
I have been served copy. Without serving copy, how the petition will be registered?
petition will be not registered without serving the copy, Your Lordship. The copy has been served. But the matter is, Your Lordship will see the
Right.
matter is, Your Lordship will see. Then, number one, petitioner file a writ petition before Your Lordship, writ petition number 192026 regarding payment of salary. Then thereafter the Honorable Court,
My lord, it was served to the
directed-
office of the senior government advocate, not to the standing council, my lord. That is for senior government advocate, my lord. That is why my SC, WPTBC or tribal affairs is not there, when the cause list also, my lord. I was not aware.
All right, now in WPC 1920,
my lord,
you are praying for release of salary.
my lord, salary.
Ah.
Already the Honorable Court,
Who represents the respondent 7?
respondent, Your Lordship will find. State of Assam represented by the Secretary of Government of Assam.
R7.
Subdivision and welfare.
Yes.
Subdivision of welfare, 7.
Lordship will take his start.
Respondent number
In
7.
the meantime, Lordship will please to issue notice. Oh, it was notice.
Till then,
It is issued. already.
Yes, my lord.
notice already issued. They have not neither filed their affidavit
No, no, next to it.
nor any reply, Your Lordship.
No,
but
2026.
Hereafter,
it takes some
Your
time.
Lordship will say, petitioner was suspended. Let them do, they have to file the affidavit, Your Lordship.
Yes, we
Without filing their affidavit, they suspended the petitioner, Your Lordship.
Is there any law that says that cannot be done?
My lord, they have to file affidavit in reply.
In to file affidavit in your writ petition,
My lord,
where you are asking for salary.
salary, my lord. They have
Now
not
they
paid
have issued the suspension order. Where is the suspension order?
Lordship pays
suspension order.
52
You
on
will
the
find, Your
subsequent.
Lordship will find. Page 52, Your Lord.
Yes.
At least say the grounds, your lord.
My writ petition,
Does it say that you have been suspended?
3244.
Because you have filed you have approached this court.
But
Does it say that you are suspended because you have approached this court? It says you have been found to be frequently absent without prior intimation.
no, my lord. These are totally false. He went to the office. They are he went to the office, but they don't allow him to join in the enter even the office, Your Lord. By high-handed manner, that the petitioner went to the office.
We'll issue notice here in item 52.
My lord, in the meantime, suspension order maybe stayed, Your Lordship. But,
Stay.
my
You can't stay. Why should we stay? There you give us prima facie material to show that this order is either not issued by the person authorized or prima facie exercise of power. Show us.
my lord, Your Lordship, I have filed a reply, Your Lordship will find page 50, Your Lordship.
50.
50. Reply of the petitioner, Your Lordship, so cause reply.
Show cause for what?
Regarding their suspension, regarding their
Which show cause?
Against the show
Well,
cause
against the
notice,
show cause
6-5, my lord. Subsequently,
so
he was
cause notice,
suspended.
Your Lord. So cause notice, page 40, Your Lord. Page 40.
Yes.
Page 40, Your Lord.
Yes.
May I read it? With references, report cited above received from the so-and-so Udalguri, it has been brought to the notice of this office that you, Sri Gautam Rajbongshi, senior assistant of the office of the SDW Udalguri, have been found frequently absent from your office.
All right, let
duty-
them obtain instructions. We are
Yeah.
issuing notice. Heard the counsel for the party.
Bora, my lord.
Existing MSB Yeah. Accepts notice on behalf of two,
Two Secretary
Three.
Tribal Affairs BPC.
three,
Two,
Three.
three, Your Lordship.
then four,
Four also,
5,
not 5 and 6. Oh, 5 are me. 5, 5.
5, then 7,
7, Your Lordship.
8,
Yes,
and 10.
10.
Mr. R or appears for 1,
1 and 6, my lord.
1 and 6. MSDD Bourbon appears for respondent number 9.
9.
So the respondent, the representative of the extra permission. The petitioner is placed under suspension. His subsistence allowance as per the procedure as per rules be released. Respondent file necessary affidavit to advise.
Then your lordship suspension order may be kept abeyance, your lordship. Till then, your lordship. Till to the returnable date, your lordship.
Why suspension order? Show us one ground that the suspension order is bad in law, prima facie.
My lord, petitioner went to the office, your lordship, you see BTC area, your lordship. The Rajbangshi, Gautam Rajbangshi, you see. He went to the office, but they don't allow him to enter in the office, your lordship.
When did you go?
His reply, your lordship, will see para 3.
No, Mr. Counsel, we are not asking you for the whole history. We are
Right.
asking you that you are praying for a stay of the suspension order.
My lord.
You show us that prima facie the suspension order is contrary to law. Show us that the person who gave the suspension order
My lord.
is not authorized or is not is in conflict with the rules. Show us something to stay the suspension order.
Your lordship will kindly peruse only for 1 minute. Your lordship will peruse the page 30, para 3, your lord. Of his reply, your lordship. Reply of suppose not.
Yes. Page 30, in which writ petition?
Page 50.
50.
No, my lord, writ petition subsequent 3244.
Yes.
3244.
Yes.
Page 50 is a reply, your lordship. Paragraph 3. Married. I did not take authorized absence become within the period of suppose and with it reminders I was at medical as attendant of my mother treatment in the ICU at Narayana
Where is your leave
Hospital.
application? Where is your leave application?
Gauhati, your lordship.
Where is your leave application?
Leave application, your lordship will find my writ petition 1920. Your lordship will page 22. Annexure 8.
Yes.
Leave application, your lordship will page 24. Annexure 9 series.
9.
Page 24, 9 series. 9.
Yes.
Married. With reference to the subject cited above, I have the honor to inform you that my mother have been suffering from critical diseases last 1 month to till that. She was treated at Narayana Hospital, Gauhati. Therefore, I need earned leave extension with effect from 1/1/2026 to 31/1/2026.
This
Sir,
does not contain any endorsement.
if you
Mr. Chaudhary does not contain any endorsement of the department. Was it received? How have you sent it?
the sub-divisional welfare officer, the respondent number,
How have you sent this application? By hand, by post,
by hand, your lordship.
by hand, then why is it not received?
By hand, your lordship.
Is it received?
Then inquiry, your lordship will see his so-called inquiry, so-called reply, your lordship. He stated everything, your lordship.
We are
Why?
asking you a
How
question,
they
you are
have-
skirting. We are asking you a question then how has this application been served in the office? By hand? Was it received? Where is the endorsement?
By hand, your lordship.
Then where is the
In the
endorsement?
table, they
Where
don't
is the
allow,
endorsement?
your lordship will see, they don't allow him enter into office even.
You could have sent it by registered post.
My lord.
You could have sent a copy by email.
Well, he sent it, you also, that is why I.
All right, Hertz, notice is returnable after 4 weeks. Respondents may file their affidavit in the meantime. Yes,
My lord,
no stay.
Till then, my lord. Till
If
then.
you want, we'll reject your stay prayer, or we can consider it on the returnable date. We are giving you 2 options.
No, my lord, the petitioner is in a critical condition, your lordship.
He
They
is not
don't
in a
allow
critical
even.
condition. His mother was going some illness. Is he also suffering from illness?
No, mother, your lordship, mother was suffering from illness, your lordship. He used to
But
attend
prima
the
facie, we don't find any irregularity.
medical report also I submitted before
Yes.
your lordship.
My lord, the name of SC WPT will phone the government.
Why can't you make a note of it? We are fixing it on a returnable date. If the registry fails to do it, don't use that as an excuse.
My lord, we are
Registry will reflect the name of all standing councils. Standing council BTC and what is that? WPT.
SCWPT.
WPT.
My lord, extra copies.
Extra copies we furnished
That may
within,
be fixed, your lordship.
within 1 week. 5th of August.
6th.
5th.
Five.
The loss, your losses, what are lost? 15.5.
Yes, respondents.
My lord, we have received instructions. We would like to file affidavit, my lord, bringing on record the entire proceedings.
Is she entitled to provisional pension? No.
No, my lord, it has been
It was
withheld.
sanctioned, my lord, but in the meantime, that already sanctioned. I have annexed also.
File your affidavit.
Sorry, wait a minute.
Is there an order passed under 21?
Yes, ma'am.
Yes, that is page 45. This is the MP order.
Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by Mr. A.M.H.R. A.H.M.R. Chaudhary. And Mr. Rai Bota for
120 excise department.
respondent 120, and Mr. R. Boro for respondent 4. The excise department will file their affidavit. Response to the contentions raised by the petition, respondents to the averments made in the petition. Previous this matter again. 17? 17 again.
Double.
Yes.
Yesterday's matter regarding the appointment of Anganwadi worker.
Some judgment you referred.
Yes, ma'am. Well, almost identical. The name judgment, ma'am. My lord, I have marked with a flag in the serial number 9. para 9, my lord, I'm ready. Having considered the matter in its entirety, though we may have sympathy for the respondent, the conduct attributed to him and the settled position of law leaves us with no option but to interfere with the impugned judgment. Public employment must be made available to all eligible candidates in accordance with the prescribed qualification. At this juncture, so my lord, what I was referring to, my lord,
There it was 8 standard.
here it is 8 standard, my lord.
No, in this case.
In this case, it is 8 standard. And
But-
there, my lord, the first thing is that he or she should not be a, my lord, regular school student, my lord.
In this case also,
In this case also.
before the apex court.
Oh, this is my lord.
What is the condition before in the matter before the apex court? It must be 8 standard, not beyond 12.
Not beyond 8.
No, not beyond 12.
12, my lord. So here, my lord, she was a regular student and had a graduation degree. Why, my lord? My lord will now come to para 10, my lord. Para 10, there it is, my lord. Why such my lord, this government being a model employer, why they take such decisions? Why? There is a motive behind it. That is what apex court has explained, my lord. In the present case, it is a manifest from the communication dated 2010-9, then by the such and such. The 8th standard and the maximum qualification prescribed was that the candidate should not have passed intermediate or 12th standard or 10 plus 2 examination. The rationale behind prescribing an upper limit of qualification in both reasonable and equitable, namely to provide employment opportunities to the person who, owing to circumstances of life, could not pursue higher education. The state, as a model employer, is justified in reserving certain categories of posts for such persons so that they are not compelled to compete with more highly qualified candidates against whom they would ordinarily stand little chance of selection. Such a policy has consistently been upheld by the court. So, my lord, here why the basic concept for Anganwadi worker was, my lord, 12 standard, my lord. We did not say, my lord, beyond 12. Basically, my lord, Anganwadi
No,
is
but the issue is not 12 for graduation. The issue is the regular student.
regular student. Exactly, my lord. So, regular. So, my lord, there is a prescribed under 309 rule, my lord, or notification. We have set it.
See, the case that you are referring to,
Yes, my lord.
ordinarily is a case where the persons who are up to a particular qualification and not beyond that. Now, what is the condition here in your advertisement?
Advertisement, my lord, it is should not be a regular student. And
this is number 3.
Number
Anganwadi government. I don't see. No. Higher secondary.
higher secondary.
Right.
Yes. Higher secondary
Now,
and
it is not a case where the writ petitioner was selected or some other person who is otherwise high secondary and satisfies all criteria has been rejected because the petitioner is a graduate.
no. Here it is rejected. Which case, my lord? Apex court or
You're saying that in this particular case, had it been that a particular candidature was rejected because the petitioner is a graduate, then this Supreme Court judgment is certainly applicable.
minus.
At the instance of that candidate whose case was rejected on the ground that she has lesser qualification. Because the requirement is higher secondary, not graduation.
My lord, similarly, my lord, I am taking a cue from what is fallen from my lord. My lord,
Here is a case where this is not even the consideration. Consideration is that she is a regular student.
exactly, my lord. She is a regular student. Why, my lord? Why we have opted for 12th? The motive behind, my lord, that has to, my lord, has to take into consideration. My lord, there are so many candidates, those who could not, my lord, carry out their further studies into graduation, my lord, and they remained, their education was kept to 12. For those, my lord, regular students, that is why we don't entertain, my lord. That is what, my lord, and my lord, there is a notification by the governor to this effect.
Where is that?
My lord, page 38 of my affidavit. That is the primary condition, my lord, for selection. This is not an advertisement, my lord. It is a notification for selection of Anganwadi worker and helpers. 38 annexure B. So, my lord will see this is the notification dated 25 January 2019. And then second page, my lord, page 39, down below. This is rejection of candidature of the following ground if allowed. 1, 2, 3, number 4, my lord. Regular student of school or college, they will get rejected. So, my lord, so long this notification is there in force, we have to, my lord, go by the notification. If my lord allows this writ petition, my lord is to strike down this notification. And this is not under challenge. We just followed the notification, my lord.
So on the date of selection, she was a regular student.
Regular student.
She obtained admission in BA course. Advertisement was published in the 2023. And she passed higher secondary examination in the 2021, which is required for applying to the post. After passing higher secondary, she obtained admission in BA course, and during that period, the advertisement was published. She applied, lordship. She applied. So
When was the selection held?
selection was held, lordship.
In your application form, what did you say? What is there in the application?
I passed higher secondary.
She, my lord, she did not disclose that she is a regular student. That is
No, that is not necessary. Option is not there. There is a standard format, lordship.
My lord,
Where is that?
Yes, lordship. Collected data on lordship.
my lord will see in page 25, the Assamese version, my lord, of the advertisement, my lord. It's very clear. Deliberately, she has suppressed the information. Actually, she should not have applied. She is barred by this notification, my lord, advertisement.
Requirement is higher secondary pass, and she has mentioned serial number 6. She is higher secondary.
The 7 you have kept it blank. অন্যান্য তথ্য
Because there is no
অন্যান্য
other
order.
qualification. Yes, lordship. Till then, graduation was not completed, lordship. She filed application on 8/12/23.
This is,
and she completed graduation in the month of July 2024. So she cannot write that she is graduated.
my lord, here is the case, my lord. We are not against the graduation.
All right, we'll keep it next week. Let us go to the judgments. Okay. Have you seen the judgment?
Lordship, I have
I have given a
judgment.
copy, my lord.
Yesterday, I forwarded one judgment, lordship, I have seen, and in that judgment also paragraph 6, the Honorable Supreme Court has expressed concern, lordship. Paragraph 6 of that judgment, lordship.
Which one?
Why Srinivasana Rao versus this one, paragraph 6. Honorable Supreme Court has expressed concern, lordship.
Yes. Son, what?
May I read, lordship? The decision to prefer an uneducated person over an educated person
amount to allowing premium over ignorance, incompetence, and consequently inefficiency.
So what are the facts here?
My lord, here these are the
Preference to be given candidates who are experienced in business.
yes, my lord,
Preference to be given to unemployed educated persons.
my lord, here regarding issuance of license of fair trade shop. And Lordship, I have connected one more judgment. My lord, here this will be not applicable. Why? Because both the candidates, my lord, the first and second, both are graduate. So, my lord, we cannot take that the other person who is in second position, he is uneducated. She is also graduate, my lord. Here is not a question of graduation, my lord. Here is an issue, my lord, between regular and non-regular students, my lord.
What is this?
This is judgment regarding Lordship may kindly see. Requirement was defarmed, but the petitioner was holding graduation.
Not like
And-
that. It does not apply. Right, released on Wednesday. Wednesday. 24th. The judgment is very good.
My lord, this one close, which I have just.
Pertains to my lord termination of the petitioner, my lord, who was engaged, my lord, in the year 2012 as block data manager on contractual basis under National Rural Health Mission, my lord. What happened, my lord? He continued his service for more than 13 years, and my lord, on June 2025, 4th June, one constable of Panchgram police station lodged an FIR alleging that, my lord, from the mobile number of the petitioner, one Facebook post was, my lord, shared on 9/5/2025, and this Facebook post is, my lord, is a disturbing one, and my lord, is hampering the my lord, integrity and against the honorable Prime Minister. Something is there, my lord, and my lord, accordingly he was arrested, my lord, and thereafter, my lord, before his bail, he was terminated from service, my lord, without any show cause notice, my lord. Nothing is there, my lord. One notification was there that he all the employees of contractual employees will continue till the age of 70 years, my lord. So, my lord, I have, my lord, your lordship may produce the impugned order, my lord, page number 36, my lord.
Lordship, before your lordship hears this matter any further, my humble apologies, lordship, this matter has been taken care of by Miss Abora, who had to leave the court because of personal difficulty. Lordship, the brief is also with her.
What are you challenging here?
My lord, this termination order, my lord,
Page number?
this 36, my lord. 36. That is, this order is a stigmatic order, my lord, because the ground is that I was arrested, my lord, in the connected PS case, and for this is the ground for which I have been terminated. And my lord, the
1 minute. When is he likely to come?
Lordship, to fix it next week also. Like, because of some personal difficulty, she had to leave. She was here on the first half.
So on Monday, we keep it on Monday.
Lordship.
Monday.
Lordship.
Submission is made on behalf of the standing council.
NHM.
NHM. This is Bora that she had to leave court. Mr. MJ Kabi, he has put the date. What? Huh?
may not reach, my lord.
Why are you giving these apprehensions? May not reach. We are not even 3 o'clock. We are reaching this matter. You wanted to make a mention at 10:30, upgrading this matter.
Oblige.
No, obliged for what? Why are you obliged?
It may come, my lord. Serially.
We are here to listen to your matters. Why do you make unnecessary, unreasonable requests to upgrade a matter, apprehending that you will not reach? You tell us that this is a matter which has to be heard today. We'll sit here the whole night if required. We assure you that. But don't make prayers just for the sake of making it.
I'm with payment.
If you have difficulty on Monday, we'll have it on Tuesday, Wednesday, you tell us. Monday, sure.
Mashallah. For my senior friend starts with it, so I have some prayer. Perhaps in the matter, Mr. TC Sudhir, our colleague, is me appearing the matter, and the matter was discussed yesterday also. So, but I think the matter was discussed yesterday also.
Was it?
It was in, my lord, it came up yesterday. Your prayer was made because this person was retiring this month. So, urgency of the matter, your lordship has fixed today.
What has happened, lordship? Mr. TC Sudhir today, lordship, he has missed the matter today. And lordship, as per his information, the file is with him, lordship, at his residence. So, lordship, he has some difficulty today.
So you are challenging what the compulsory retirement?
Yes. My lord, there are 3 points which I have put to challenge. First point is that, my lord, under 9(2) of the disciplinary appeal rule, my lord, the DA has issued a so cause. Correct, my lord. Now, that so cause, now joint secretary issue a enquiry officer. Now that enquiry officer is DA. DA is the enquiry officer. C enquires the, my lord, the enquiry, and enquiry report for who
issues the show cause?
So cause is issued under 9(2) by the DA, my lord, disciplinary authority.
Where is it?
Yes. Please see, my lord, my lord, page 71. 71, my lord.
Secretary.
My lord, page 71. Please see, in exercise of power conferred under Rule 9(2) of the Assam Service Discipline Range under so and so hereby direct to so cause as to what disciplinary proceedings shall not be initiated against you. Now, please see on the top, my lord, from so and so Secretary Government of Assam. What you got it? Name. Name is important, my lord.
Yes.
Right, my lord. Now, please see my reply at page 76. I'll tell what was the issue, my lord. Please see at page 76 reply.
Yes.
Now, thereafter, enquiry officer was appointed. Please see at page 88. This is a basic I am showing. Whether they could have proceeded or not. Please see 88. 88. Now, kindly see. In exercise of so and so, Assam dated, I am directed to communicate herewith the enquiry report submitted by the enquiry officer. Now, this is what is submitted by the enquiry officer so and so related to departmental proceeding drawn up against you by so-called dated so and so. Now, if you see, my lord, affidavit in opposition, my lord, please see for a moment, troubling at page 160. By side, my lord, please see the affidavit at 160, my lord. 160 of the affidavit. Now, please see, this is, my lord, on 24th of January. Now, third paragraph. Now, therefore, in excess of power conferred by sub-rule 4 of rule 9 of so and so, appoints the Anusha Datta Barua, secretary to the government of Assam, food and so as the enquiry officer. Two enquiry charges framed against so and so. Now, under 9(2), C is a DA, and an enquiry officer was appointed. C was appointed enquiry officer. And now thereafter, an enquiry report has been furnished by her. Now, C acts as a DA,
And on the basis of that, a major penalty has been imposed on me, saying that compulsory retirement. This is the only that same person. Please see 136 of the impugn order. Please see 136, ma'am.
You come to 9(4).
9(4). Yes.
There is a power of the disciplinary authority to inquire into the charges. 9(4).
9(4), ma'am.
Yes. Rule 9(4). After issuance of show cause and receipt of the defense.
Well, I could not.
1964 rules.
Yes, yes. 9(4).
Yes. 9(4).
9(4), ma'am. 9(4).
Yes.
On receipt of the written statement of defense, or if no such statement is received within the time specified, the DA may itself inquire into such of the charges as are not admitted, or if not considered it necessary so to do, appoint for the purpose of board of inquiry or an inquiry officer.
So DA has the power to inquire on its own, or may appoint an inquiry officer.
Now what it has been done? My lord, here is a case where, my lord, DA has issued a show cause. My lord, see the fact. DA has issued show cause under 9(2). Now, on the basis of 9(2) issuing a show cause, the inquiry was conducted by DA itself.
Right.
And DA has imposed a major penalty.
That is the provision.
Major penalty.
So the provision is provided under the.
Now, please see.
There is no bar for the DA to make inquiry.
And also terminate.
That is what the provision says.
Not the same person.
Normally not done, but the power is
Normally
there.
not done.
No, the power is there. If you
Normally
see,
not done.
if you come to 9(A),
Yes.
of the same rules, you come to 9(A).
Yes.
This is the communication of orders. This also reflects.
Please.
This 9(A) of the rules.
Yes.
If you are holding this book, then this is 438. (9)A, subsequent amendment. (9)A also gives a
Orders
hint.
made by DA shall be communicated to the government servant, who shall also be supplied with a copy of report of the inquiry, if any, held by DA, and a copy of finding on his charge, and where DA is not the inquiry authority.
Therefore, the DA can be the inquiring authority, and after holding inquiry, serve copies. And where the DA is not the inquiring authority, then if you disagree with the finding, then also you serve copies. But if you disagree with the finding, then you give a note of disagreement. So, DA being inquiry officer per se is not in conflict with the.
But that may not be a proper. My lord, he issue, my lord, a show cause.
That's what the rules say.
But second point again, my lord, whether they can rely on a preliminary inquiry report.
That is the
No, that's number one. If your lordship ignored this first point.
No, I can't ignore.
No, first point. No, that ignore means what I am saying that if it is not contemplated under rules, then the second point, what do you?
Once the regular inquiry is there, the preliminary inquiry will lose its significance. But anyway, this matter will require some hearing.
Actually, this man is going to retire.
But he's already.
No, he's going to retire.
He's compulsorily retired, isn't he?
Yes.
Now, is there an interim order?
There is no interim order. Compulsory retire, but his date of retirement would have been 30th of June.
If the court comes to a conclusion that this proceeding is bad and the orders passed are bad, whatever benefits are there, will be entitled to him.
That's true, Mike.
Only thing we may not be able to give him is that to have the pleasure of joining back, assuming the writ petition is allowed. Otherwise, benefits will be.
But second point, if this point goes against us, the second point is that whether they could have relied on a preliminary inquiry report. Whole case is based, inquiry report is based on preliminary inquiry. And that copy, that was not served to us, neither they did not call us for hearing. Whether they could have done it.
Preliminary inquiry.
Yes. And that particular, as per judgment of the Supreme Court, you can't do it. That was because if you see the inquiry report.
There is a judgment by this court also.
Yes. Yes.
I don't know.
Yes, I am.
Regarding this.
Yes. No, even then, my lord, inquiry report, if you see the entire inquiry report, they said the entire inquiry report is based on the preliminary inquiry. Now, if that be the case, you did not invite me. And you could not have, if you would not have relied on a inquiry report, then it would have been a different thing altogether. They relied on the inquiry report, preliminary inquiry report. Please see page 90, my lord. Yes. Inquiry report starts from 90 and please see 102. Now 5C, the finding of the inquiry report.
When is the petitioner retiring?
30th
Of?
actually, of this June.
June.
Yes.
Done.
I'm sorry.
Then we may not be able to.
No, I know, I understand. I understand.
That extent.
Yes, of course.
Because this will require some hearing.
Yes.
You can have it immediately after the reopening.
It's okay, man. Subject to the outcome, man. Whatever I am entitled to get.
Yes, yes.
That your logic can reflect.
Heard Mr. D. Das, Senior Counsel, assisted by Mr. K. Mr. C.P.L. State. Scope is the same. You have compulsory retirement. Against it. Petitioner has urged, petitioner is saying this particular proceedings on two grounds, primarily, namely, that the disciplinary authority ought not to have been the inquiry officer. Thereby causing prejudice to the petitioner. That the preliminary inquiry, which the petitioner will never bring such inquiry, they could not have been relied upon. Compulsory retirement. Respondents have your file, pleadings are complete.
Yes.
Pleadings are complete, pleadings are exchanged. Matter be listed immediately after the opening. The records pertaining to the departmental proceedings be kept made available for perusal of the court if the needs were arise. Please don't tell us anything. 16th of July.
There is one judgment on this first point. First point of where Lordship has pointed out. I just forgot. My learned firm.
Give us the judgment.
Yes, please look, your Lordship can look into the judgment. That is 2018, 7 SCC page 670. I can give a copy.
No, no, take it out. 670.
670 and paragraph 28, there are, if you read the 4 lines, we have noticed above. We have to read the entire judgment, but what it reflects, para 28. And if you read the para 28, the last 4 lines, we have noticed above the High Court found breach of principle of natural justice in enquiry officer acting as a prosecutor against the respondent. Enquiry officer who has to be independent and not representative of the disciplinary authority, if starts acting in any other capacity and proceed to act in a manner as it is interested in eliciting evidence to punish and employ the principle of bias comes into place. This is what I just forgot. That's why I took up the first point. This way has
This is where the enquiry officer also steps into the role of a presenting officer.
Yes.
This judgment.
Yes.
Therefore, that cannot
But
be
that
done.
also, analogy can be drawn here also. Here, if you read the entire judgment, you will also find out. My lord, I will not trouble today itself, my lord. Today cannot be a date of hearing, but if you see the order, that's what was troubling at page 136. You'll also keep the judgment. 136 of that order.
Just a minute.
Yes.
We relied on this one, so judgment. 136
of the writ petition.
Yes.
And you see 137. So the enquiry officer is acting on his report. Please see 137. Please see 137. Same enquiry officer is acting on his report. So now the analogy of enquiry officer cannot be a presenting officer of any department. Here also acting on his report. That's proposition, my lord. I think that has to be looked into this by court, my lord. No, just I am putting it this way. Can an enquiry officer can rely on her own report and pass an interim? No, that's what, my lord, the judgment of the Supreme Court. The rules are there, my lord, but what it says, judgment, my lord. I think that's not,
unless the rules are,
that's not fair, my lord. What I feel, my lord.
but then you'll have to challenge the rules.
That's what if the judgment of the Supreme
Court
Court.
for interpretation of the rules. You're right that the enquiry officer has to be dispassionate, independent.
Yes.
Only then, because it is a quasi-judicial
That's
function.
That's what the Supreme Court said. It's a
Right.
quasi-judicial.
But if the rules permit,
Yes.
that is how the inquiry is held by the department.
Then apparently it appeared that will be total biased. Maybe your lordship is right that one has to challenge the rule. One has to challenge the rule. That's
you're right in
once
the apprehension expressed that inquiry officer has to be unbiased.
But
now
once
the departmental disciplinary authority is the authority prima facie satisfied that proceeding should be initiated.
Yes.
How far that partiality is there? You can
ultimately that's also right. To some extent, your lordship's hands are also tight when there is a rule. One has to come and challenge that rule. That's the whole problem.
The challenge.
One, nobody has come and challenged that. When I found, we don't find. Sometimes we find that DA under 9(2) issue.
Normally it is
then
not done.
yes. Then I have checked one judgment which I did. My learned friend said there is one judgment. I also put the same question to him. But there is a judgment of the Supreme Court. Of course, that has been looked into it. Facts of that case. I'm deeply obliged.
Take it up after the reopening.
Pilot, where the petitioner my lord, appeared in an interview for the post of technician, technician CSS, and for assistant technician CSS. For both the posts he appeared, my lord. And my lord, he was successful in the written examination and shortlisted for appearing in the my lord, oral test, my lord.
Yes.
Subsequently, he was not given appointment. So this is my case, my lord. So here the respondents have filed the affidavit. Your lordship may kindly turn to page 54 of the affidavit, my lord. Here, para 4, my lord, I am reading from the middle, my lord, that he was found eligible for the technician CSS and technician CSS. However, the cutoff mark in respect of the aforesaid 2 posts was 67 marks, unreserved category, and the petitioner herein obtained 35.8 marks only in his written test. As such, on that count, the petitioner was not appointed for the aforesaid 2 posts. Then, my lord, your lordship may kindly peruse annexure E at page 29, my lord. Of my writ petition, page 29. Notice, this is for information of all concerned that the candidates who appeared in the written examination for grade 3 technician post under Directorate Medical Education so and so, under the following roll numbers have been shortlisted on the basis of marks secured in the written examination, and they are hereby directed to appear in the skill test and document verification. So, my lord, here the petitioner name also appeared, my lord, page 30 and 31. 30, my lord, your tick mark, my lord, for technician for CSS. Petitioner's roll number 1217046. Then next page, my lord, technician assistant for CSS. 1217046. So for both the posts, he was found eligible, my lord, in the written test. And now here in the affidavit, they are saying, since he, my lord, obtained 38 marks, the petitioner was not appointed for the 2 posts. And
What is the process for selection? Written test then?
And skill test, my lord.
Skill test.
And they have, my lord, annexed the list also, selection list also. Your lordship may kindly see the list. The petitioner's name appeared, my lord, at page 58, my lord. 58, serial number 30. Here, your lordship may kindly see in the, my lord, status, my lord, column of status, he was found eligible. So since he was found eligible, he should have been given appointment, my lord.
Serial number?
Serial number 30, 30, page 58.
30.
The lordship may kindly see the status column, eligible.
He was eligible, he should have been given the skill test. He was not called
No,
for
my
skill
lord,
test.
for both the tests. Your lordship may kindly see the marks. He appeared, marks of the written test as well as skill test. This is the final select list for my lord appointment.
This is the mark sheet.
This
Mark
is mark
sheet
sheet.
for
Yes, my lord. In the mark sheet column is there, my lord,
written
that he
test
is
and skill
eligible.
test.
Mark sheet for written test as well as skill test.
Skill test.
Yes, my lord. And on the basis of the mark sheet, status was given as eligible. And on the basis of this list, my lord, selection, my lord, the petitioners are given appointment, my lord. My lord, the candidates are given appointment.
How many posts are there?
Post, my lord, 55 posts, my lord. I have given the, my lord, I have annexed the vacancy position, my lord, at page 24, my lord.
So are you saying that so he obtained the marks 54?
Yes, my lord.
Total marks.
Yes.
So anyone below him appointed?
Yes, my lord, appointed. My lord, kindly see the vacancy position, page 26. Serial number 48, my lord. Total post 55. And general, for general, my lord.
20?
Page 26.
26. Yes.
Total 55. And for general, my lord, 27, my lord. And for technician CSS, total 48. For general, 25, my lord. But if it's still now, my lord, my appointments are being given, my lord, but all the posts are not yet filled up, my lord. Since they are found eligible, they may be given appointment, my lord. there are some candidates who secured less marks, and some of the candidates who, my lord, passed from, my lord, the private institution, my lord, they were also given appointment, my lord. But as per the advertisement, my lord,
So you tell me, you come to page number 57 and 58. You will find the names are listed in terms of the marks achieved.
yes, my lord.
So the highest mark is at serial number 106.
Yes, ma'am.
So your marks achieved is 54. Above you, there are several persons belonging to the general category who has scored more marks.
Below me also candidates.
Below you also, there are a lot of persons who are scoring higher marks, but they are provisionally selected for whatever, maybe some documents they have not given.
Settlement, they are selected, they will be
Huh?
given appointment.
Yes, what do you say?
Actually, the counsel appearing for the health department, he was in court, but his mother fell sick, so he had to.
Who is the counsel?
Lordship, you come in.
He was here in the matter.
Yes.
Then?
Suddenly, he got a call that his mother fell sick. He had to- Lordship, any other date other than any date.
On Monday. We don't want to hear that excuse again. Monday.
Yes, sir.
List on Monday on the request made by on behalf of the health department counsel that he had to leave court because of medical emergency.
Similar.
Similar, Monday. Yes, pertains to compassionate family pension roadside. It is, Assistant Director, Medical Care has already filed their affidavit. In their affidavit, they stated that I am entitled for the compassionate family pension. Why are they not released?
Lordship, we have sent the pension proposal to the Accountant General, my lord. Actually, what happened, my lord, we were actually about to upload it to the Kritaketa portal, my lord, but it was not uploaded because of the fact that he was holding an NPS account, the deceased employee. So, my lord, it was not uploaded. So, we have to send the pension proposal through offline.
Physically.
Yes, ma'am.
It was returned back long back. I've given it instruction.
When did you send it?
Long back.
Again, when did you resubmit?
Yes, matter, my lord, then.
NPS. He was holding an NPS account.
So when did you send it to the department? Twenty-six, 2022. Accountant General, you have returned it back. Is it? When? That the image of the deceased employee lordship, nothing has been taken to their picture. So you see, you filed this affidavit here.
No,
Assistant Respondent 3.
Yes, madam.
Now, there is a statement that you have submitted offline.
Yes.
On which date?
Date is not specific, madam.
Then it is a 24. If you have submitted it on 24, it is hardly something that you should put it in an affidavit filed on 26. Now, if it is NPS, what happens?
NPS, my lord, the NPS authority will sanction the pension. As compassionate pension is concerned, that's a different issue. What happens, my lord, if a person dies in harness, my lord, till the date he would have retired from service, till that day, the family gets the salary that he would have won as pension. So this they would be getting apart from the NPS. Now the proposal has to come, my lord. So far as my instruction goes, my lord, it was returned back, that hard copy, because they do not accept it anymore, the hard copy form. It has to be uploaded.
Now, why can it not be uploaded in the portal?
That instruction, I'll have to take note.
Why can it not be uploaded?
Lordship, as per
As
my
per their
affidavit,
statement, Lordship, I am entitled for NPS. That into this NPS,
it was
my-
already holding an NPS account, my lord, and for which, my lord, under this portal, it was not.
so NPS means portion deducted from him and
Yes.
another part deposited by the government.
No.
So that, who is to disperse this amount?
The
Dispersal will be from the
NPS authority.
NPS authority.
Yes, you'll have to make an application.
So who is the NPS authority?
Autonomous body. And I am a subscriber of NPS, my lord. Well, not an employee, even private persons can subscribe. Something happens to me, my family has to make an application. That's what is the knowledge. Employees are concerned, my lord, what is the procedure, I'm not sure, but definitely we'll have to make an application.
And it's paragraph 14 of their affidavit, paragraph 14. Here stands that with regard to paragraph 11 of the repetition, the answering deponent states that as the documents were not submitted by the petitioner timely, the service of the deceased husband of the petitioner was considered under NPS. Otherwise, I am entitled for the OPS lordship. But not submitting the papers in time, they have enlisted my name in the NPS lordship. Now your husband was there having an NPS account. Yes, sir. So you'll have to now apply to the NPS authority. Why are you seeking a direction against the respondents to release the papers? Now, why did you, if he's holding an NPS, then why have you forwarded the papers to the pension department?
the accountant.
Accountant general.
It's done by the office, my lord. I have
That is why, my lord,
Occupation and family pension.
compensation and family pension stands on a different footing. What happens, my lord, if somebody dies in harness?
So what are you now claiming? Tell me. For compensation and family pension, lordship. I'm paying before this. Now, who is to release this compensation and family pension?
Account, they will have to sanction it, will authorize the payment, but for that, the process has to be initiated. Now,
They, according to them, they have already sent it.
it was returned back. So,
When did you send it? You have no information.
that is not
filing the writ petition, my lord. It's given, the date is
But
given.
page 26 of the affidavit, resubmitted through offline route
offline.
before the office of the accountant.
date-
When?
Date is not.
That is not confirmed. Thereafter, they state in paragraph 16, lordship.
It has to be, my lord, after 2025, my lord, 26/6/2025, because, my lord, on that date, my lord, the same was, I have written in paragraph number 12, my lord.
Perhaps there were some errors, lordship, in paragraph 15 of their affidavit. That with regard to the paragraph 12 of the petition, the answering deponent states that the respondent authorities are trying hard to fulfill and rectify different errors, finalize and sanction her compensation and family pension very shortly.
Submission.
You get instructions, both pension and sericulture. What is this sericulture? Sericulture. Get it?
Because, my lord, at paragraph number 12, my lord, we have stated that the pension proposal was, we have forwarded to the director of sericulture, Assam. Thereafter, it has been,
In July 2025, it was returned back. by
yes.
the AG.
And
The
thereafter, my
reason
lord,
was not uploaded in the Criticata portal by the department, and also the GPF number was not given. Since he is a subscriber of NPS, my lord, there will be no GPF number.
Submitted at the bar that the Department of Sericulture, that the Department of the Accountant General's office had returned back the pension proposal, compassionate family pension
They say,
proposal to the administrative department, that is the Sericulture, Department of Sericulture. The learned standing council for the Department of Sericulture submits that it was resubmitted again.
the document is dated 9th of July 2025.
Which document?
The resubmission document is from the Assistant Director of Sericulture to the Accountant General's office. It's dated 9th of July 2025.
Then what happened after that?
Thereafter, we have returned it back, my lord, because it was not uploaded to the Kritagata portal and the GPF number was not provided. We have asked them to rectify.
When did you return it?
July, month of July 2025. NHF, my lord, the date is given there, my lord. Page 22.
The council for the Accountant General submits that the proposal which was sent by the Department of Sericulture (9th of July 2025), the Accountant General's office returned back by the Office of the Accountant General, raising certain queries. Stop. It is submitted that thereafter there is no information from the administrative department as to the resubmission of the papers. MS Bora, learned counsel representing the Sericulture department, on the other hand, submits that they had resubmitted the papers. Therefore,
True offline.
offline mode. However, she has no information as to the date on which the resubmission was made. Matter therefore has to be deferred, enabling the respondents to complete their instructions in the matter. Released again after reopening.
Yeah, pray one thing, let's say, till finalization of this matter, let's say, I may be allowed to hold the provisional from my parental department, let's say. So many financial hardship is there also.
Provisional compassionate family pension. Lord.
If the rules permit for release of provisional pension, department will endeavor the same during the pendency of the bill. Released on 17th of July.
I'm assailing a transfer order, my lord. There's a direction of this code dated, my lord, 26/5/2026. And in pursuance to that, they have filed an affidavit. My lord will kindly take up the affidavit. They have annexed some extract of meeting. In fact, that was produced on that day, that other date also.
Where is that?
Lordship will find page 100, annexure 1 of the affidavit opposition. See this extract doesn't contain any reason, my lords.
What is this extract?
These extract of recommendation of Board of Officers assembled at TTE General CRPF in connection with representation preferred by the petitioner against his transfer to so-and-so sector Bengaluru during Somerset transfer 2026. Course number is there. I am the petitioner. Everything request remarks are there, but recommendation is.
What is the ground? What is the ground for request for reconsideration?
Well, I have two grounds. One is though not explicitly covered by the standing order, but my lords, I'm the only male surviving member of the family, and I'm from the state of Manipur. That part, my lords, I have also completed the prescribed cooling off period. I have been out. I was out of 6 years is the period. I have overcome the 6 periods. Now I'm eligible for to be redeployed at my lords Manipur. And also, my lords, when I applied for the authority, representative for the authority, they just simply said rejected. On that ground, my lord, they were asked to produce records and file an affidavit if so advisement. But they have filed with this affidavit, which even their earlier court order, this court's order, my lord, doesn't, which has discussed this statement. There's no reason whatsoever, my lord. I was relieved from Manipur from 2019 and 2020. Now I have completed 6 years, 6 years, 4 months.
Yes, Mr.
Lordship, can you see his detail of posting at page 30? Out of 31 years of service, Lordship, he was within the northeastern zone for 29 years and at his home state for 20 years. So, Lordship, we have, being a all India Lordship, this force, Lordship, we have to maintain that they have to serve the south. He have never been in the southern region. Only once he has been in the western region for 2 years only. And where he has been sent? He has been sent to Bangalore, Lordship, where he will have all the medical facilities. He is raising a ground of his wife treatment. He has been at Jorhat since 2019, out of Manipur since 2019. The wife can stay there at Manipur, Lordship, since 2019. Now we can take to Bangalore, Lordship. Which city has the best of the educational facilities and medical facilities, Lordship. And he will be getting the accommodation there, Lordship, because he is not in the competent force, he is in the office. He is the clerical, ministerial staff. He will be enjoying at the office, AC office, Lordship.
You are entitled to family accommodation.
Well, that's a different issue altogether, my lords. This, what my learned scene is showing, my lords, and trying to impress upon that page 30, it was never on my application. It was on their own, my lords. In whole of my career, I have never approached the court. These postings, it was from their own, my lords.
The idea you tell us one thing that what is the ground on which you don't want to go besides the fact that there are some domestic issues? Unless these are accepted by the
whenever he joined
by the rules or by some notification. Well,
my lord, in that case, my lord, they could have verified they could have exercised their discretion and passed a reason order, because I also raise a claim that I fulfill that cooling period of 6 years. From 2019, now I'm out of Manipur.
Period of 6 years from where is that notification transfer posting?
Notification is, my lord, no. Standing on 31. Well, page 31, also you find the heading. Then page 38 minutes.
38.
15.15. Cooling off minus the normal cooling off of subsequent posting of homestead and NCR will be 6 years. 2, the cooling off period for subsequent posting in associate and Cobra will normally be 6 years. The cooling off previous period of posting will normally be 6 years. This order being an administrative order, my lord, they cannot shy away from giving reasons, my lord. There appears to be no application of mine, my lord. Simplicity rejected.
But whatever reasons you're asking for, these reasons,
because my lord,
is it germane to your prayers? I mean,
it's not exceptional case.
No, my lord, they have to provide me reasons, because in that case, because I can go for appeal also before the DG against this order. So, in that case, my lord, because my cooling off period, that they have admitted. That this cooling off period, they're not disputing.
They're not disputing this. And this all that page 30 posting, that was not on my behest. I have
Go and
never,
file an appeal
they
and
have kept me
ask
there,
them
my
to-
lords.
Huh?
They have kept me there in Manipur all these years.
There is an appellate provision, go and file an appeal.
And in fact, my lords, look, you will see when I represented, they ought to have come with something, my lords. Page 100.
Way we are trying to
My lords.
understand your submission that you are covered by some provision in the.
Yes, my lord, that is I'm showing, my lord, page 15, that point 15, because I'm
15 is cooling off period.
cooling off period. That is the reason, my lord, I represented before them that I have fulfilled this cooling off. Consider my transfer back to Manipur. And the other part, Manipur situation, lordship knows. I'm a resident of Imphal, and there's no male member to look after my family, man.
So take them along.
take his
them with
family
you.
to
I
Bangalore.
have 6 family members, man.
Take them with Bangalore.
3 orphans, 3 ladies. Is it possible, my lords? My salary, with this salary, my lords,
Yes, Mr. Chakravarti.
This
This
guidelines,
cooling off period provided in the clause 50 provides for 6 years for subsequent posting in homestay.
Lordship,
Why
Lordship, he has already been in Manipur for 20 years, Lordship.
not on that 20 years, 30 years, 40 years? We are going by the your own.
And more so, Lordship, this guidelines
Regulation.
doesn't give her any enforceable right that has been established, Lordship. I'll be relying on that SK Nausat case, Lordship.
No, we understand that. But tell me one
And
thing.
we have to
Tell
accommodate
me one
everyone.
thing that if it doesn't give any enforceable right, why have the notification? For what purpose?
For checks and balances.
Check and balances for what?
Lordship. Guidelines are made.
But check and balances
can be-
say don't give enforceable rights. Then how will you enforce the check and balances? Because it's either you follow, you may say that no, there can be variations because of German reason.
The reason,
So this 15 law says cooling period is 6 years. And after that you can go for a homestay. You have to give a reason why this.
because he has never served outside the northeastern
So give
region.
that reason. Give that reason.
Lordship, we have stated in the
Not in the affidavit, in the order. The order doesn't disclose anything. His request is for transfer.
in the remarks column, Lordship, we have stated that he has been in the northeast since 2012. That is the point taken into consideration where these cases.
Well, it's okay, but the notification says.
Lordship can do one thing. You will file within 1 week, let him file a press representation that will be disposed of within.
So we will direct the matter to
With
be
the
reconsidered.
reason order that will pass a
We
reason.
direct the matter to be reconsidered. We will say that this order at page number 100,
Lordship.
remarks or whatever order, we revisit and pass a detailed order. Whatever you heard counsel for parties, petition filed by the petitioner, challenge. Is transfer order, where is the transfer order?
transfer order.
Where is the transfer order?
Well, the transfer order is at what my side transfer order.
Transfer order dated so and so. According to the petitioner, he is entitled to in his home state, which is Manipur, in view of the fact that the petitioner has satisfied the the prescription under clause 15 of the transfer and posting
Transfer order,
guidelines.
73,
It is
Lordship,
submitted that
73.
its representation preferred before the authority expressing his hardship on account of his family and other domestic problems, not addressed properly by the respondent authorities, taking into account the transfer and posting guidelines. Being agreed, respondents have filed an affidavit where the order rejecting his representation where the extract of the recommendation of the board of officers in respect of the request made for the representation is said extract, it is shown that the request made by the petitioner is for transfer to any Manipur-based office to look after his family / other domestic problems, which is not recommended, primarily on the ground that he is posted in the Northeast since 2012. He is to recommend, not recommended, not recommended. The learned CGC, referring to the said extract, submits that the remarks column reflects that his case was not recommended, perhaps because it is stated there that he is posted in the Northeast since 2012. Per contra, Mr.
In fact, he has in 29 years in Northeastern region.
according
Out
to
of
the
31
learned
years of
CGC,
service.
spent 29 years in
Out of 31 years of service.
Learned Council for the petition, referring to clause 15, 1 submits that employee is entitled to be posted in a home state after the cooling off period from his earlier posting is satisfied, which is normally 6 years. Last posting of the petitioner in the home state was?
My lord, it was in the year 2017 to 2019.
Is in 2017 to 2019. Therefore, since he has satisfied the cooling period, his prayer for seeking posting in state of Manipur should be permitted. Stop it is further submitted that the extract of the recommendation does not reflect that the provisions of the transfer and posting guidelines has been considered, duly considered by the respondents. Therefore, submits that the impugned order be set aside and the petitioner be allowed to stay in the state of Manipur. The third council. Standing order.
Clause 6 and 7 also says merely applying for a particular reason is not a guarantee. Also,
reflects that provides us under stakeholder 1, 3.
Page 34.
Which one?
Page 34, clause 6 and 7. More particularly 6A, Lordship. Filling of the preference is not a guarantee for posting to preferred unit. Also, no can claim it to any particular post or location.
Standing order
6A.
prescribes
The last
that,
line, Lordship. Last 2 lines.
filling up of preferences will not be considered to be a guarantee for posting in the preferred unit or establishment.
Also,
And
no
no
official personnel can claim
may claim
for any particular post or location.
However, perusal of the recommendation is found that reference made standing orders while rejecting the recommendation of the petition. Under such circumstances, the matter is remitted back to the respondent authorities, reconsider the application of the applications/preference of the petitioner for being posted in his home state of Manipur. So the authority will reconsider the matter and pass a detailed order, a reasoned order, by taking into consideration the provisions of the standing order 04 or let this order be issued within
let him file within a 1 week and within,
No, he's not filing, we are remitting it back. Why do you want him to file it?
within 1 month from the date of submitting the certified copy.
Within a period of 30 days from the date of receipt of a certified copy, submitted by the petition before the concerned authorities. The interim order passed will continue till such order is passed by the respondent authority or till 30